that those matters which were fixed in the previous week but could not be taken up, that will appear as to be mentioned, and it will, and a date will be fixed. Without mentioning, please hand over those slips and state the date on which it was fixed, date and time.
Yes. My lord, last date. It was returnable on 12th May.
Yes. Those matters. No. I'm just previous week. Previous week, those which were fixed but could not be taken up, that will be appear. Yours?
To be mentioned.
Yes, to be mentioned. No. Which was fixed, definitely. No matters were listed in the previous week. Yes. Just a minute. Let these matters be.
This matter already had 2 days. 14th was the fix.
Anyway, previous week, if it is fixed, definitely it will be again fixed and taken up. Yes, now with regard to applications.
May I permit to mention, Lordship?
Just one by one.
Well, I am not left to mention 2 applications.
Just wait. Let the applications be filed first.
Application, Lordship, for extension of interim order,
Yes,
Lordship.
give it.
Your Lordship.
The application.
Yes, all applications, please hand over.
Lordship, for correction.
To be mentioned.
For correction, my lord.
Correction, yes, to be mentioned.
2 part matter.
Yes, which correction you are mentioning? The review matter?
Yes, my lord. Only name correction, my lord. 2 matters, my lord, were fixed last week, my lord. Since the bench was not available, my lord. This is my part matter.
No. The date was fixed in the previous week.
Previous.
Yes, then give it. It will appear as to be mentioned and then date will be fixed.
May I permit to mention, Lordship, one civil revisional application of 2017 regarding short deposit. 2 or 3 minutes matter, Lordship.
No. Is it ready for hearing?
Yeah, ready for hearing, Lordship.
2017?
2017.
Yes, give it.
My lord,
Notice, Lordship, I am mentioning, Lordship, I have already served notice.
my lord, may I leave to mention is the second appeal matters is for the inclusion, my lord.
Inclusion for hearing?
Yes, my lord.
Okay, after 2 weeks.
After 2 weeks will be mentioned.
After 2 weeks, it will appear.
Yes, good. Grateful, my lord.
Hearing matter, all formalities complete. On 8th, I have already mentioned your lordship dated the matter to appear after 2 weeks. I'm mentioning again.
2 weeks has expired.
Yes,
Anyway, let it appear as to be mentioned.
With regard to item number 180.
Yes, just a minute. Outside the list, any other?
Yes, my lord.
Hearing? Yes, after 2 weeks.
May I be permitted to mention one matter, my lord? The matter was supposed to be fixed on 7th of May, my lord. However, since then, my lord, it has not been taken up, my lord.
Okay, hearing, ready for hearing?
Yes, my lord.
Yes, to be mentioned. Yes, now in the list.
With regard
My
to
lord.
item number 182 at page 272. It was mentioned, my lord, twice before your lord.
182.
182. So, appeal for, my lord, by client. And Mr. Rajesh Singh appears. I've given it, my lord. Your lord, my lord, 2 occasions I mentioned.
So this matter was heard earlier.
No, my lord, what happened, my lord, 2 occasions I mentioned, your lordship desired to place the matter as to be mentioned for fixing a date.
Okay, so acha, let it 182 after 2 weeks, let it appear as to be mentioned. Okay, if it is reached, well and good. Otherwise, after 2 weeks, it will appear as to be mentioned.
My lord, with regards item number 137 and 138, the Oriental Insurance Company versus Chiranjoy Das. My lord, Mr. Singh filed this appeal, my lord. My client, my lord, 75% disabled, and my lord, he has been removed from service from Indian military. But your lordship, he is present also, my lord. He is, my lord, suffering a lot.
No, question is, if it is not taken up,
Yes.
I shall fix a date after 2 weeks. Okay. Yes. Just wait. You see, chronologically, if it is taken up, well and good. Otherwise, after 2 weeks, I shall take it up.
My lord, I am waiting for last 4 months. That is why, my lord.
Anyway, I shall take it up.
So, my lord, I can hand over the slip.
You can hand it over, but you just wait for the If you see, if it is not taken up chronologically, definitely,
My lord, one thing can be done, my lord, Sir Rashid Khan, update under that heading, my lord. Update that, my lord, under that heading, that it can be.
you see, either it has to be taken up chronologically or a date has to be fixed. You just wait.
উঠছে না, যাচ্ছে না অব্দি, তার আগেগুলো হয়ে যাচ্ছে।
My lord,
Anyway, just wait for some
my
time.
lord, I'm considering to mention item 22 of days list. My lord has some fixed matters in the first half. That's why I'm mentioning. My lord,
Item
Ek-
22, you are appealing
20.
for?
I'm for the petitioner, my lord.
Yes.
My lord, I have prayed for extension. My lord has some fixed matters and second half hearing matters would be taken up.
No, no,
I was just
wait. No,
hoping
no.
it can
If
be
the
taken.
matter is not reached,
My lord.
mentioned.
My lord, I'll do
It
that.
will be
Grateful.
extended.
Well, the matter is running, today's is submitted by lot. It has been heard.
Item?
71 by lot. May kindly fix any date, my lord, any time, my lord.
Okay, it is appearing in the list. When to be mentioned will be taken up, definitely date will be fixed.
My lord, may I have your kind leave to mention, my lord, the applicant has.
May I hand over the list, my lord?
No, no. You see, to be mentioned matters will be taken up. On that day,
That will work.
the date will be fixed.
My lord, the applicant has been signed and the details and minutes.
Yes,
It was the matter, my lord.
yes, to be mentioned.
Obliged.
My lord, two to be mentioned matter and one application, my lord.
Give it.
Need a application.
Am I permitted to mention such matters?
Yes, what for hearing?
My lord, to be mentioned, my lord, for hearing.
I'm appearing for the petitioner. Kindly not today, my lord.
No, this matter was heard. I told you to take some instructions
That instruction
and file a report or whatever it is in that matter.
directed us to inquire the order
Yes,
by which, my lord, the special officer was appointed.
yes, those,
No, that
yes,
order-
that order.
That order has come to me.
Please show us. No, regarding the functions of the special officer.
Special officer getting dealing with only that purpose. Special
No,
officer
no,
is not-
question is, this is the office order, okay?
Right.
Now, you see, prior to that, there must be some policy decisions that the corporation authority has taken up the policy to appoint special officer for so and so purpose. That policy decision must be there. From there, you can.
Your Lordship, my lord, that one of the issue, because it had been going, my lord, over the years until that judgment, my lord, passed by my lord Mr. Horish, and thereafter the law is there. Now the law is, my lord, regarding the
Very,
special officer
very well.
there.
That is binding. Okay.
Right.
Let us see whether this.
Yeah, my lord, that order, I will make my submission over whatever the submission.
No,
they have
but on the
advised.
next day after they complete, you have to make your submissions, but come with those policy decisions.
But that one of the regarding the policy which to appoint, because it is the under the act, well, there are some powers have been given that of course well that was dealt with by my lord Horish in the civil division case, where I, my lord, submitted that the corporation on contractual basis appointed some persons from the outside of the not being the employee of the corporation. That, my lord, that is the reason the Lordship is fine, my lord, the 6 months, that is the order. Then next page, you have seen the next page.
Second
6
page.
months, for 6 months, my lord, he was appointed. And then, my lord, he was extended that is particular under the particular provision.
Now the
Now the
functions,
question, my lord, came.
the functions, the
There is no, my lord, dispute about the functioning by the special officer regarding dealing with the unauthorized construction. There is no dispute about that. All through. That is not the issue. No, my lord, no one.
but was those policy decisions, this assignment order placed before the honorable judge dealing with this
That
matter?
was not required by honorable any bench, my lord,
No, no,
because
very well. You see,
it was,
that judgment is binding.
continuing. My lord, it was continuing. I tell you, Lordship, it was continuing when the earlier act, which stood, my lord, repealed and a new act has come into force. That act 1951, that was continuing since thereafter on such basis. Now, my lord, that question cropped up and raised by one of the in one case that regarding the special officer functioning or appointment, all these things that was dealt with. if I go, definitely some that decision or something like must
Policy
be there.
decision was
But,
there.
that might be very difficult. I will inquire if Lordship will ask me. But it might be difficult because it is of long past. Whether it is there or not.
Definitely it will be there. You see, first of all, a policy decision is taken. Thereafter, these appointments are made. And thereafter, the functions are assigned. That you have to assign swans. You have been.
Function only there 400 section 1 and no other function.
So where do we get this? From the appointment order?
From the appointment order, my lord.
That he is to discharge functions. That is why these policy decisions and this function.
It says because the special officer, when it says the billing, therefore only he will deal with their billing matters.
No, but what purpose regarding this unauthorized, this hearing? What were the functions he was assigned? That is to be seen. That is why this policy decision is necessary. You see two things. One is this order. This is the appointment order. The other is this. Prior to this, there was a policy decision. The other is the task which was assigned. Because if 401, nothing appears from this order. So I'm giving you 2 weeks time. Okay, you see. Otherwise, I will dispose the matter after 2 weeks.
Well, I may explore because my learner's point is different. My point.
I will hear him. Okay, but let these things be clarified. Okay, the decision is also has binding effect, and the Honorable Supreme Court has.
So that is well a binding effect because there is the other side of the coin. That will not place before us. That is my duty.
You will, after they conclude, you will make your submissions after 2 weeks. But on that day, you collect this policy decision.
I will inquire, but this
if necessary, you make your written notes.
I will explore the situation, my lord. But I may submit, my lord, that may be that possibly not the issue before Lordship right now, because he is not raising that issue, my lord, before Lordship.
Very well. Let us.
He is inquiring about that. It's a good.
Let us know that. Okay.
That's a different.
Yes.
And also, my lord, retrospective effect has to be taken into consideration.
Anyway, all things will be taken into consideration. Yes, record an order. Learned advocates for the parties are present. Mr. Ghosh, learned counsel appearing for the Corporation Authority, has submitted the order dated 27/7/2012 appointment regarding appointing of the special officer. Stop.
That is Mr. Pal. You should first of all inquire whether Mr. Pal was
special officer. I have not mentioned the name. Learned counsel is requested to take necessary instructions and file the policy decisions in relation to the appointment of special officers under section 401 of the Act, as well as the order assigning certain functions to the special officer. Let this matter appear on 13/7/2026. 13 Monday.
Well, I'll try my level, but I it might be difficult to get it out.
Otherwise, the picture will not be clear.
I already to appear.
13. Monday week.
I am for the petition.
Yes, you are for petitioners.
Your Lordship, 8th June, my lord, your Lordship.
Item 14.
14.
Yes. What is this application? Can 2?
Can 2, your Lordship, district road, your Lordship, 8th June, your Lordship, passed the order.
Okay. Today is for what? Compliance report?
Zero.
Yes, record an order. Learned advocate for the petitioner is present. In terms of order dated 8/6/2026, the cost which was awarded is paid to the High Court Legal Service Committee, Calcutta. Stop. Thus, the order dated 8/6/2026 is made absolute. Can 3 of 2026 stands disposed by condoning the delay and recalling the order dated 8/4/2019 passed in CO number 246 of 2007. This application is restored to its file and number. The matter be listed on 13/7/2026.
13/7.
Service, if not made in the meantime, be made upon the respondents.
And next matter is the same, my lord.
15 also? Just. খালি সিও নাম্বারটা চেঞ্জ হবে সিও নাম্বারটা 246 ডেট অফ ডিসমিসাল ইজ দ্য সেম
Same.
তাহলে শুধু সিও নাম্বারটা রেস্টোরেশন 247 হবে 46 এর জায়গায় অর্ডার ডেটটা সেম হবে
Compliance report.
ইয়েস সেম অর্ডার
The opposite part, Lord. My lord, this is a restoration application.
so this Canford is your application
My lord. Already, Lordship, I filed the opposition. It was not a simplicity restoration application, Lordship.
let us see
My lord, at page 5, my lord.
just a minute you filed this application in time
My lord. That is, my lord, page 5 of the application, my
Page.
lord. What happened on 5th July?
no
2000
page 5 just a minute page 5
Page 5 of the application.
yes
My lord, what happened, my lord, on 5th July, paragraph 10. On 5th July 2024, the petitioner did not take step, his lordship was taken that the petitioner has not filed an application for substitution, but that has been filed within time after the order passed, that is at
no what is the order let me see that is page
only annexed, my lord,
5/7/2024
5/7/2024.
yes No, the matter was dismissed for not taking steps in terms of,
That step has already been taken, that has not been, my lord, brought.
that
to
was
the
not brought to the notice of the
notice
court.
the honorable justice.
Okay, so on 5/7/2024, the matter was dismissed for not taking steps.
My lord,
and
CAN 3, my lord, kindly see,
CAN
CAN 3
3.
has been filed for substitution
When that was filed, prior to the order or
prior
after?
to the order. That has been filed on 24th May 2024. After the order passed on 16th May 2024.
CAN 3 was filed
On 24th May 2024. After the order passed on 16th May 2024. My lord, at page 4, my lord, in paragraph 6, I have stated.
paragraph.
Page 6, paragraph 4.
Page 4, paragraph 6.
The petitioner stated that at the time of hearing on 16th May 2024, learned advocate appeared on behalf of the opposite party number 1. First time submitted before the honorable court that the opposite party number 1 died on 5th December 2022, leaving behind his wife and his two daughters, such and such. And as per the, and after that, the Honorable Court directed to file a substitution application of the opposite party number 1 after setting aside of the abatement. Can application number 3 of 2024 on 24/5/2024.
So
I have-
that application can 3 is disposed.
No,
So that has to be disposed
That-
first.
my lord,
Then
on
only
that
the,
point, the petition has been dismissed.
no, unless this application,
Because on that date, my lord, the advocate of the petitioner went to the doctor,
otherwise, how many opposite parties are there? 2 opposite parties.
only one.
Only one opposite party. Sole opposite party died.
No,
You are representing whom? The heirs of the opposite party.
yes, three times dismissed.
I will first come to this question.
Yes,
You are
I am the legal
representing-
heirs of the opposite
You are
party.
representing
Legal heirs of the opposite party now one.
how many legal heirs are there?
3.
Okay, so this whole opposite party died and all the legal heirs are now before the court. You are representing them.
Loss.
So where is your Can 3 application? Let's take up. Can 3 কোথায়? কি Can 3 কোথায় dispose হয়েছে? Okay, Can 3 is not appearing in the list.
No. That
Okay,
is the
let
problem.
us see. Have you been served with the
Yes,
copy?
yes.
Can 3 have not filed any opposition?
No, I am filing opposition against the Can 4.
Okay, that is restoration application.
Loss,
Okay, let us take up Can 3.
loss of, initially seen the Can 1. That is the dismissal order of 2012. That was also not
Now,
restored.
that was earlier restored.
That was not restored.
My lord, what happened in 2012, the matter has been dismissed for default. One restoration application has been filed in Can 1. That has been dismissed for default.
That was not
Can 2
restored.
has been filed.
That was also dismissed.
For that, my lord, the petitioner
means
made no
earlier-
objection.
Earlier
Earlier advocate
revision.
did not appear.
No, this is
I
earlier
have
revision.
stated in my application, my lord.
So earlier revisional application, okay, that was dismissed for default.
My lord,
So
Earlier twice.
twice has been
when it was dismissed for,
Loss, I giving the
okay, so your revisional application dates of 2009.
my lord.
So first it was dismissed for default.
No, there is the interim order also passed.
Anyway, some
After
interim.
that, my lord, that has been dismissed for default. A Can application, Can 1 has been filed. That Can 1 also dismissed for default. Can 2 has been filed. My lord, thereafter the petitioner took the no objection from the from the earlier advocate. Thereafter, another advocate appeared, and my lord, on 16/5/2024, the order has been passed for substitution, granting the leave for setting aside of abatement. Thereafter, setting aside of abatement, that is, Can 3 has been filed. But unfortunately, on 5th July 2024, there was no date fixed for the sitting of the honorable judge.
How many applications this court has to dispose? One is this, now one is the substitution
My
application.
lord, the
Can 3 is the
Can,
substitution.
Can 1 is the restoration.
read,
Can 2
Now come back from the back side. Okay.
I have
Now
read
Can 4 is the restoration of Can 3.
Can 1 and 2 and my lord, the revisional
Because
application.
you see, your Can 3 application was for restoration of the restoration application.
No,
Can 3 was
no,
composite.
my lord, Can 3 is the application for substitution after setting aside of abatement.
So Can 3 is the.
Can 1 and Can 2 are the restoration application.
Okay, Can 1 is for restoration of the main application.
Main application.
And Can 2 is the restoration of the
restoration application.
restoration.
No, that was not prayed. In the prayer I showing, that was not prayed.
Okay, now.
That is the fault on the earlier advocate.
Okay,
That is
now the question is,
what
you
can-
see, now this court has to take up this Can 3 first before taking up other matters. Because Can 3 is substitution
My
application.
lord, until the order dated 5 July 2024.
Okay, Can 3 substitution is already dismissed.
No, all that has not been bring to the notice of the honorable judge. That's why, my lord, my application has been dismissed for non-compliance of the order dated
Loss,
16 May 2024.
loss, in the meantime, loss order was executed.
No, no.
Delivery of possession
no,
was
no,
done.
no,
I
no.
showing this from the
Okay,
order
that
sheet.
will be considered latter stage.
Showing.
Okay, 5/7/2024. On that point of time, Can 1 and Can 2 were appearing in the list. Okay. Now what happened is this.
My lord,
3206 is dismissed for default, although this order is of no effect because 3206 was earlier dismissed for default. Main revisional application, connected application, Can 1 of Can and Can 2 are also dismissed for default. Anyway, 3206 was already dismissed for
but
default.
Can 3 has not been to the notice of the honorable
Okay.
judge.
So Can 3 also ultimately you see, no, this 3206 of 2009 is of no effect.
My lord, the revisional application has been dismissed only on the point
So that was
the
earlier.
non-compliance of the order dated.
Very well, you see, because you see 3206 dismissal is of no effect. You see, because earlier dismissed, so it is of no effect. Now the thing is this, Can 1 and Can 2. So that means Can 1 is for restoration of this earlier revisional application and Can 2 is for substitute. Oh, that is restoration of the
restoration application.
That pair was not done.
Okay, let us see this Can 1. Just
Can 1 lawsuit.
Can 1, what is your ground for not being present?
That was also 1 day delay. That was not explained.
My lord, prior to that, my lord, this 5 July 2024 order should be, my lord, recalled, my lord. Otherwise, my lord, that cannot be taken up.
No, no.
5/7/2024.
My lord. My lord, the application under Can 4, my lord.
So you are praying for recalling of this order 5/7/2024.
Then, my lord, that Can will be revived, my lord.
Can 3 is for substitution. Anyway, Can 3 did not appear in that list.
That is the difficulty, my lord.
Is it appearing today?
No, my lord.
So Can 3, you are for restoration of recalling of this order.
Can 3 for the substitution after setting aside of abatement. That has been granted leave on 16th May 2024.
16th May 2024. Can 3 disposal দেখাচ্ছে দেখুন এটা disposal দেখাচ্ছে কিনা রেকর্ডে
But there is no order.
No, if Can 3 is already disposed, no question of further orders.
No, my lord, Can 3 has not been disposed of. Kindly see the order impugned, my lord. The order has been passed for non-compliance of order dated 16/5/2000.
That may be by, if it is by mistake, let us see. ওটা কি ডিসপোজড হয়েছে কোথায় দেখুন কারণ লিস্টে শো করছে না তো
পাঁচশো চব্বিশে কি করে ডিসপোজ অফ হবে ওটার জন্যই তো হয়নি দ্যাট ইজ দি রং রেকর্ডিং
আচ্ছা ক্যান্সিটা একটু বার করে দিন তো
5/7/2024 না অর্ডারটা বার করো
5/7/24 অর্ডার তো আছে অ্যাপ্লিকেশন আমি তো সাবমিট করেছি অ্যাপ্লিকেশন 4 আছে My lord, that order is in can number 4.
Just then this application is being taken up for the time being. We are now in Can 4.
Lawsuit,
Order pass
no, lawsuit Can 3 filed after 5th July 2024 order. Can 3 and Can 4, lawsuit Can 4, 9th July.
Can 4 is for Rest that is recording.
9th July, same day lordship.
No, Can 3 has been filed prior.
At that point of time, Can 3 is not
24th May.
there.
Can 3, just a minute. Can 3.
24th May, that has been filed. Can 3, 24th May, that has been filed. I have stated.
Yes,
in-
24th May.
My lord, that is prior to that. And that has not been bring to the notice of the honorable judge.
Okay.
Otherwise, my lord, that order will not be passed.
It was dismissed earlier when? CO 3206?
3206 was dismissed on 13/12/2023. Thereafter,
13, 12, 23.
23.
No.
Main revisional application.
Main division also was dismissed for default 13/12/2012.
2012. For which you took out Can 1.
Can 1,
Can 1 of 2012.
13.
Okay, and this Can 1 was dismissed on?
Can 1 also.
February 2024.
For which you took out Can 2.
Can 2. My lord, this is a change brief. I am not there, my lord, at that point of time.
This is not a ground lordship.
No. Can 3 is for substitution.
Can 3 is substitution.
And Can 4 is again
Can
dismissal.
4 for restoration, my lord. For recalling of the earlier order dated 5th July 2024. My lord, that order has been passed on the sole point that the order has not been complied with.
No. Lordship, kindly see the 5th July order. So many things also stated lordship. I placed this order, lordship, misleading the court.
No, I am not misleading.
Paragraph number 3
Paragraph 3?
of the order dated 5th July 2024 lordship.
Yes.
Being aggrieved and disturbed with the impugned order, the present revision apply is preferred at the behest of the petitioner. It is submitted by the learned counsel for the opposite party 1 that an execution proceeding was taken out, and the decretal property was already handed over in favor of the decree holder opposite party number 1. It is further brought to the notice of this court that during pendency of the case before the opposite party number 1 expired, and his heirs and legal representative were duly brought on record. Only the trial court already on record. On earlier occasion,
how they duly brought on
Yes,
record?
on earlier occasion.
On earlier occasion, the petitioner were directed to take appropriate steps on the event of the death of the opposite party number 1, but no step have been taken by the petitioner. In such circumstances, I find no justification in the keeping in the instant revision applicant alive in the list. The same being CO number is dismissed for
Here,
default.
my lord, step has been taken prior to that order. That has not been bring to the notice of the honorable judge.
Yes, just
That is the duty of the opposite
okay.
party.
What is your opposition? Let us see in this for.
Yes, boss.
অপোজিশনটা দেখি ক্যান 4 এ
Opposition start করেনি? My lord, the opposition they have
What it
filed,
was?
my lord, not with me, my lord. That has been changed, my lord. If I have a copy.
You serve him a copy?
Yes, yes.
Oh, we have not served copy.
No, already I earlier advocate already served.
Anyway, if you have a spare copy, please give him.
Today, not spare COVID, I place it lost thereafter I handed over. Lost first paragraph number 8 of my opposition.
Did
With
you
the-
file any or you did not file any reply?
No, my lord, because I have no knowledge about their filing of opposition. my lord.
Para 8.
Para 8 lost.
Yes.
My opinion. With reference to the statement contained paragraph
My
3
lord,
of the
kindly give me a chance, my lord, to file the reply if it
Let
is
me see.
required.
Just let me see.
this deponent denied dispute does not admit anything save an answer which do appear from the record of this case. This deponent state that the application being CAN number 1 of 2013, old CAN number 361 of 2013 for recalling of the
Para 8.
para 8
With reference to statements contained in paragraph 3.
Lordship. Order dated 13/12/2012 filed on 14th January 2013 out of the prescribed time limit, but neither giving any explanation for delay nor file any separate application for condemnation of delay. Moreover, no explanation was given in the said application regarding non-appearance of the learned advocate of the petitioner on 13/12/2012 at the time of hearing of the present divisional application against the first.
You see, regarding there is another application CAN 3. CAN 3 is substitution and setting aside abatement. You don't have any objection to this because you are representing the legal heirs now.
Yes, already in the trial court already name was already
My lord,
included.
that
I
to be
placing this
bring
order.
before-
If
that
my
the
dispute, I
heirs should
placing
be
this order.
bring before in this matter, my lord,
Okay, now
because lower court the substitution will not carry out.
paragraph
here.
8. Paragraph 8 is your contention.
Regarding CAN 1 filed beyond time limit. The delay was there, but no explanation, no separate application was filed, and no explanation was given for non-appearance of the learned advocate of the petitioner. Thereafter, lordship, para 13.
Para 13, it ends up to paragraph 11. Your affidavit in opposition.
Reference regarding paragraph 12 and 13.
Okay.
With reference to the statement contained in paragraph number 12 and 13 of the deponent denies and disputed.
Which paragraph you are reading? This is.
What is lordship?
This is 620. এই এটা দেখো বার করুন এফিডেভিট ইন অপোজিশন টু CAN 4 এটা বার করুন
Para 8 regarding CAN 1, old
Para 8, yes.
Initial restoration application. Paragraph 8 already stated that there is a delay that was not explained. Also not explanation where the learned advocate not appearing at the time of call. Thereafter, lordship, paragraph number 13 regarding paragraph number 12 and 13 of this application. This deponent denied and disputed does not admit anything save an access which do appear from the record of this case. This deponent state that the learned advocate Mr. Lokshinath Bhattacharya, who appear on behalf of the petitioner applicant on and from 16 January 2024, so that question of negligence on the part of the erstwhile learned advocate, no objection, and went to the doctor chamber on 5th July 2020. All are baseless as well as false
Okay,
excuse.
you are not having a copy of the opposition. You serve him a copy, you want to file a reply.
My lord, if it is
So
required,
better, no, because if you want to file a reply, I'm granting you that opportunity. Come with a reply and a list of dates of all the events.
Already I bring the list of this and relevant orders also, annexing the.
No, if your learned
Yes,
friend
yes,
wants to
yes,
file
yes.
the reply, let him file a reply.
Yes,
Yes, record an order. Learned advocates for the parties are present. Let the affidavit in opposition filed to CAN 4 of 2024 be kept with the record. Affidavit in reply be filed within 1 week. Let this matter appear on 13/7/2026. Come with a synopsis, list of dates.
Here in item number 18.
Item 18.
Obliged, Lord.
Probably on the last occasion, I adjourned the matter, granting you opportunity to produce the copy of the deed.
Yes, it was given to the party which had purchased. That is the opposite party number. We were also given liberty.
We couldn't.
You see the last order, okay?
No, that's in lordship there is a wrongly recorded. Now, 18 now.
Yes, 15/6.
Yes,
Yes,
the order
you are
was parties
requested to
produce a copy of the deed executed in the auction. I am told, my lord, we have made searches, we couldn't find the certified copy. Now, the other side, my lord, if they have, because they have the deed in original, they are the beneficiaries of the sale.
My lord, as per my knowledge, there was no sale deed. The purchase was done on the.
No, it has to be registered. The property had to be registered. Stamp duty had to be paid, even if it is auction sale.
But the property was purchased on the basis of sale notice.
No. Question is registration has to be done. Can you obtain certified copy?
I mean, Lord, we made searches, we found that there was no registration. Now, even if there is a certificate, that has to be registered. Now, we have, my instructions are that despite diligent searches, we could not obtain any inkling of any registered document. So, my lord, if any such, if they are available, we can take a copy out and show your lordship. On the face of it, my lord, it was a cartel, my lord, which completely took over the game. Now, the certificate, if they can produce before your lordship, the sale certificate on the which that particular instrument would
very
be
well, you see, regarding sale price, there is no dispute. But the market value of the property,
yes,
that is only in dispute.
the sale certificate itself would have those similar endorsements on top if it is registered, the top sheet. The top sheet will contain market value.
No, this
It's unregistered as of now because we couldn't find any entry. We searched.
This is certificate of sale of immovable property.
Yes. So that is the sale certificate which is issued by the DRT. Ordinarily, it is issued, my lord, after, my lord, post certificate sales, that is post decretal sales. But now, my lord, it has been issued as a pre-decretal sale as a result of this exercise. Now, even if it is issued in that fashion, that has to be registered. That's my understanding of the law. And stamp duty has to be paid because instrument may be that of a sale certificate, but the effect of the instrument would be to put the entire stamp duty. Stampability is a different issue altogether. Wherever there is a transfer, it has to be stamped. And then additionally, because it's a transfer in excess of 100 rupees of immovable property, it has to be registered. Now, if that has not been done, then today, my lord, they don't even hold title pursuant to the auction sale, which is another feather in my cap. I will be very happy if they say so.
Then you just inquire into this issue.
There is another, we were about to conclude. There was a third limb of our submissions that is regarding cartelization, where from the records we can show that the ultimate beneficiary Sharoda Cereals, the controllers and managers of Sharoda Cereals, that is the company which held the shares in Sharoda Cereals, were in fact present in all the other entities in the so-called auction. All other entities except one were controlled and managed by the persons controlling Sharoda Cereals. So it was a closed door, rigged bidding process, as a result of which that lower price became.
Anyway, ultimately this has to be ascertained.
Yes,
otherwise, a special officer has to be appointed to go and find out from the registry office. Anyway, I'm granting you 2 more weeks' time. You just inquire into this
আনতে
matter.
পারবো কিছু?
So valuation is the main issue.
I can understand. Oh, I'll tell you what the problem is. We have made extensive searches. It appears that they have not put this into registration. If they have not put this into registration, that's even my learned friend appearing for the OP2 is saying that they have not put it into for
Let them
registration.
take instruction with regard to that. Yes, record.
Kindly do not formulate that question so that she can come up with the answer.
Learned advocates for the parties are present. By order dated 15/6/2026, the learned advocates for the parties were requested to produce a copy of sale deed which was executed in the auction as per order of the learned debt recovery tribunal to ascertain the market value and the stamp duty paid. Stop. Learned advocate for the petitioner submits that after extensive searches, no such registered instrument is found. It is further submitted that they could not obtain any instructions as to whether the sale document was at all registered. In the facts and circumstances, the matter stands adjourned till
Only one prayer. My lord, I have not found anything in the registry. Therefore, I am sure that no sale instrument has been registered.
So
now, my lord, the opposite party number 2 is submitting that there is the sale place on the basis of a sales certificate, a copy of which he is handing over, which shows that it is unregistered.
13/7/2026 for the learned advocates for the opposite party to ascertain as to whether the sale document was registered. In the event the sale document is registered, to obtain necessary particulars of the same.
My lord, I'm appealing for the opposite party number 2, my lord.
Yes.
My lord, very well, my lord. I have heard what your lordship has already directed. If it is, my lord, I will take instruction from my client. Kindly do not record what my learned junior has submitted before your lordship.
Yes,
because
sale certificate.
Yes, that's there.
Yes, no. She has produced the sale certificate, whether it is registered or not, my lord. Regarding that, my lord, I have to take proper instruction from my client.
That opportunity I've granted.
Yes.
My lord, kindly keep the photostat copy of the sales certificate on record.
You take a copy. Let the copy of the sale certificate file be kept with the record.
We can
and a copy be handed over to the learned advocate for the petitioner.
Well, mark these matters as partly heard.
It is already part heard.
But in the list,
the matter be treated as part heard.
I am obliged, your lordship, my lord.
Yes, I am for the petition. Lord, I am appealing for the Hooghly member, my lord. I have not been served with a copy, my lord. Kindly direct them to serve me a copy, my lord.
Lord, I have no difficulty to serve, but it is the 3rd time I am serving. I have the episode service I can show. Twice I have served. I have that service, my lord, with me, my lord. I have no difficulty in serving. But that I have not received.
My lord, thank you.
Well, I have the my lord episode service. Of 2015, the matter was dismissed for default. Restoration was served. Section 5 was served. Your lordship, sitting in code number 550, was pleased to take up the matter. Your lordship imposed cost upon me. I paid the same. The matter was restored. Thereafter, it was also served. Twice I have served.
Okay, let them come ready.
Yes, there is no difficulty. I will serve.
Yes, learned advocates for the parties are present. On the prayer of learned advocate for the opposite party, let this matter stands adjourned till 13/7/2026.
While I understand, he was opposite party number 1 only.
Yes, my lord.
Opposite party number 1.
Well, if service be kept with the record.
Let the affidavit of service file be kept with the record.
Grateful to lordship. So number. 23, I appear for the Union of India.
20.
20. Railway Authority, my lord. And your
This
lordship
revision application will
called for the record, lower court records.
Yes.
So far that is concerned, my management can prepare paperwork, but I am taking a preliminary point. This is an appealable order. He has filed revision.
Under section 23, my lord, any order passed by the tribunal.
Let us see.
My lord,
23.
my lord, a claim case was allowed by the learned tribunal.
Claim case?
Was allowed by the learned tribunal.
So you are appealing for?
I am for the my lord appeal.
Claimant. So the claim case allowed.
Allowed, but
you are agreed by the quantum.
no. My lord, before passing of the judgment,
Yes.
one of the claimant died. There's two claimants, parents. Parents preferred the claim application for the date of their son. Award has passed, but the one of the claimant, mother of the deceased died before the award was passed. I took out an application for substitution. After my lord, the award has passed. That application was disallowed. I filed an application, my lord, for review. That is also dismissed by the learned tribunal.
Judgment passed
Not,
against dead person.
two things. Either the amount will go in favor of the claimant on his substituting.
No, what is the order under challenge?
Well, last page 20 after 23. Consider the submissions of made by both the sides, learned counsel.
12/7/2011.
12.
Yes.
My lord.
Which order? Or 26/2015? Which one you are challenging?
Order dated 2/6/2016. 2/6 or 2016.
2/6/2015.
No, it will be 16, my lord.
In my record, it is 2/6/2015.
From the cause title appears, my lord, the order is dated 2nd June 2016.
16. অর্ডারে ডেটটা দেখা যাচ্ছে না অর্ডারের ডেটটা দেখা যাচ্ছে না
And the order sheet, entire order sheet has not been annexed in my copy.
Oh, this application is already admitted earlier.
Admission.
Admitted blood, admitted blood,
Whether
the old
it is
application blood.
maintainable or not, that
The substitution application dismissed.
They are part of the file application for review.
Substitution application, condonation of delay, and after the judgment is delivered, court become functus officio.
How?
Any order passed by the tribunal is, my lord, appealable.
Application blood.
Your lordship once peruse the section 23 of the railway claims case, my lord.
No, actually, you see, the order was passed after the hearing was concluded.
Yes.
After the hearing was concluded, the party died.
One of the party.
After judgment delivered, the party died.
No. Before the judgment delivered. Before judgment is delivered.
Anyway, if before judgment is delivered, the application does not have it.
One is already there. One claimant is there.
Very well. Now, this claimant has some legal heirs.
Yes, parents.
There are two, my lord.
Parents, my lord. Father and mother.
One died. So, my lord, judgment passed against it. One of the person died against a dead person. And thereafter, the railway authority asked for particulars. Then it came to know that one of the person died. Then, after the judgment delivered, everything is complete. He filed an application for substitution. That was rejected. Then application for review with section 5. That was rejected. Against that come. This is court cannot decide.
Learned tribunals
correction by your
while rejected my application.
Because you see, after the hearing is concluded, if somebody dies also, the case and the appeal or suit is not abated.
Died before judgment.
Maybe, but after the hearing was concluded.
Yes.
Judgmented date ta kobe bolben?
My lord, the evidence was adduced on my lord 11th of August 2028.
Prepare a
Judge award passed on.
list of this paper book, my plan for it. Prepare, my lord. Your lordship kindly keep it the maintainability point open.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates, let this matter appear on 20th July 2026.
And he should file paper book in the meantime.
This is a revisional application.
Subject. And only
Learned advocates are requested to.
maintainability point open.
Yes, learned advocates are requested to come with list of dates and the points of law with regard to maintainability.
One thing, like two claimants on died, even if the application is maintainable, entire amount will go to the one of the claimants, the substitute claimant.
Anyway, that has
So,
to be
there is no
clarified.
That has to be clarified. If your lordship hold, my lord, to be given. If your lordship holds, my lord, he has to file an appeal. My lord, he has to take back and file an appeal, my lord.
Okay.
My lord,
2-0.
2-0.
no appeal is required. আমার নামটা সাইদুর রহমান লিস্টে আছে
I am for the petitioner in this case.
Opposite party number 1.
Lordship, this is the case where the plaintiff, being the opposite party hearing, has filed a suit for declaration and injunction against the petitioner as well as others, Lordship. Thereafter, Lordship, that suit has been decreed ex parte. And Lordship, the petitioner filed an application under Order 9, Rule 13 for setting aside of ex parte decree, which has been rejected in both the courts, and that is why this present revisional application. Now, Lordship, in a nutshell, let me. I'm sorry.
Yes.
Lordship, in a nutshell, let me allow to place the case, Lordship. Lordship, the father of the Lordship, they are all petitioners and petitioners.
This application was for setting aside ex parte degree.
Lordship, this is my application for setting aside.
So, what was the ground of rejection? Let us see.
Lordship.
By the trial court.
Lordship, this is a case, Lordship. The parties are brothers and sisters, Lordship.
Now, let us see the order.
Lordship, before I place, Lordship, let me say in a nutshell the story, Lordship. The parties are brothers and sisters here in Lordship. The father of the parties, Lordship, has gifted a certain portion of his land.
No, I am not going into the merits. Order 9, Rule 13.
Lordship, unless
scope is limited.
Lordship, unless I place this, Lordship, the rejection here, Lordship, there is.
First of all, let us see the order.
Lordship, then kindly come to page 30, Lordship.
Yes, page 30.
Page 30, Lordship. Peruse the record. The present petitioner filed the instant miscase under Order 9, Rule 13 is set aside. The ex parte decree passed means title suit such and such. The petitioner stated that the present opposite party fraudulently obtained the signature of the petitioner on a wakalatnama and some demi papers. The petitioner was not aware of title suit number such and such. From the record, it appears.
No, this is order dated 4/9/2015.
Lordship, this is the first order outline Rule 13 rejection by the trial court, Lordship.
No, page 30.
Page 30, 30.
Annexure P3.
Annexure P3, my lord.
Yes.
And Lordship, from the record, it appears that the present petitioner appeared on 29/9/12, and it was ordered to proceed the suit ex parte against the defendant number 1, while the order number 6 dated 27/2/2013. From the body of the judgment, it also appears that the suit was preceded ex parte against the defendant number 1. But from the judgment and order ordered in such and such, it appears that the suit was decreed partly in favor of the plaintiff, but without cost. The right title interest of the suit was declared in favor of the plaintiff and all the defendants. It was also specifically ordered that the plaintiff did not get permanent injunction against the defendant number 1. It means that the present court has passed the judgment and decree in such and such against all the defendants, including the defendant number 1. Now, the defendant has the following courses open to him when ex parte decree has been passed. Lordship, the judge has stated the following courses, that is section 96 CPC orders 47, order 9, rule 13, and the review. And lastly, he stated
Was the
that
defendant number one in the
I am the
trial?
defendant number one in the suit, Lordship.
Okay, so decree was passed ex parte against you.
Decree was passed ex parte against me, Lordship.
Yes.
That is why I have come here. Lordship, in the suit, they have challenged that gift deed that has
Wait,
been
let us
given by
see.
me.
He may apply.
Given to me, Lordship.
So this is page 31.
31. And Lordship, the appeal court's order, may I place, Lordship?
Yes. This is the 14th June 2016.
Yes, my lord. This is starting from page down. Lordship, internal page number 3, Lordship, of the appeal court's order, where it has been mentioned, and thus it is not a case where the prayer of the plaintiff has been allowed in totality as been asked for by the prayer portion in the prayer portion of the plaint. On the contrary, the impugned ex parte judgment and order declared the right of the plaintiff as well as defendants, including the present appellant herein. In the given circumstances, I have no hesitation to hold that the learned trial court has rightly observed that the prayer of the plaintiff was to be allowed, setting aside the ex parte judgment and decree where the rights of plaintiff as well as the other defendants have been declared. The court therefore cannot set aside the same where the rights of the parties of the suit has been declared. The observation of the learned trial court that the right course of action to challenge the order ought to have been preferring an appeal is perfectly and in accordance with law, and I am in union of the same view, and that is why I ordered that this has been rejected.
Okay, what was the nature of the suit? Declaration.
Declaration, Lordship. What happened, Lordship? The father of the parties, Lordship, gifted a certain portion of land to the defendant number 1. Lordship, the defendant number, the plaintiff is the brother of the defendant number 1. Now, Lordship, after the death of the father, Lordship, the defendant plaintiff, that is the brother of the defendant number 1, and other defendants are the other sisters, Lordship. The brother of the defendant number 1 filed a suit for declaration of cancellation of the gift deed that has been gifted to me by my father, where the plaintiff was not at all a party in that proceeding, neither the other defendants.
But the deed was cancelled.
Deed was cancelled by the suit, Lordship. And now, Lordship, the court is saying that all the plaintiff and defendants have this given share, Lordship. But
Let us see the original decree.
Lordship, the original order, Lordship, I also.
No, the ex parte decree. Let us.
Lordship, yes. That is Lordship. Let me place it, Lordship. It is starting from page 14, my lord. No, my lord. I'm sorry. 18, my lord. It is started, and the final ordering portion is page 24, from 18 to 24, Lordship. That is the order. It has been reasons. The court has declared the portion for the plaintiff and defendant of that portion of which they are not at all the owner, without hearing me, declared that the deed is void, the deed of gift is void.
No, question is, it was this thing a partition suit.
It is declaration injunction.
Oh, declaration and injunction.
Injunction, Lordship.
Cancellation.
And what declaration? That the plot of the land that has been gifted to me has to be cancelled. That deed has to be cancelled. And that has been cancelled without hearing me. And I have repeatedly stated that I am just literate to that extent that I can only put my signature. I am not at all much more literate and physically disabled woman. I stay alone, Lordship. Some people came, my brother came, I trusted him. He asked me to put my signature so that that deed can be executed. That deed which has been executed by my father to me. I believing him and I put my signature wherever he stated, including a Vakalatnama, including some demi papers. Lordship, I
The
have
gift
stated that.
executed in your favor is challenged.
That has been challenged by my brother, where I have not been heard. Without hearing me, Lordship, that has been declared, that has been nullified, Lordship. প্লেনটা কোথায়? হ্যাঁ, প্লেনটার কথা প্লেনটা কোথায়? প্লেনটাই কোথায়? কোথায় প্লেন? আমি একটা প্লেন দেখলাম। এটা তো লোয়ার কোর্টের স্পেশাল অর্ডার একটা রয়েছে, গ্রাউন্ডের একটা পাতা রয়েছে।
Yes, the suit property is the property which was gifted to you.
Gifted to me, Lordship, by my father. And neither the plaintiff nor the other defendants were a party to that. How can, without hearing me, Lordship, the court considers that the deed
My lord,
Yes,
is
please.
that in law?
my lord, kindly come to page 6 of the revisional application, paragraph 5. My lord has had every knowledge of the suit, my lord.
Page 6.
Page 6, paragraph 5. The petitioner states that on 4th September 2014, petitioner received a notice from the BLLRO. The petitioner consulted regarding the same with some local people of her village, and thereafter she went to the learned court at Malda, where she came to know that a judgment and decree was passed on 19th March 2014 against the petitioner in title suit such and such, preferred by the opposite party number 1, that is her brother. The petitioner was shocked to know all these happenings. My lord, kindly come to then, my lord, page 80, the judgment and decree of the lower trial court, my lord. A certified copy was obtained on 22nd.
Page 18.
Yes, my lord.
Anyway, the trial court condoned the delay, but went in the did not dismiss on the
Yes, my
ground
lord.
of
My
limitation.
lord, kindly come to, my lord, page 30, my lord.
Page
30. 30 and my lord, before that, page 20, my lord. Page 20, my lord, trial court recorded that the suit is proceeding ex parte against the defendant number 1. She
Just
did
a
not
minute.
file any written statement.
Yes, that is our case. We have stated that we haven't filed written
My
statement.
lord, petitioner has every knowledge of the
No,
suit,
my lord, that is my case.
No, but the ground for rejection is that
Petitioner has obtained the certified copy in 2014. She cannot claim that she has no knowledge, my lord.
Lordship, the decree has been passed itself in 2014. That
And
thereafter
she has
she came
stated,
to, she
my lord,
came to
from
knowledge and thereafter
September she got knowledge, my lord.
no, my lord, the decree has
From
been
the
passed
above
in
point, my lord.
decree has been passed in March, and she has approached the BLRO on September. She has not stated that in September she came to know.
37 2015.
And my lord, kindly come to page 30, my lord. Once.
No, this section 5 application was filed along with this. Setting aside.
File হয়েছিল? Setting aside of decree, হ্যাঁ? File হয়েছিল?
No, you see, opposite party means, you see, you.
Kindly come to page 30, my lord.
Page 39.
30.
30, yes.
Yes, my lord. Kindly come to the person hard considered, peruse the record. The
Art consider.
peruse the record.
Yes.
The present petitioner filed the instant miss case under Order 9, Rule 13 CPC to set aside the ex parte decree passed against her in TS 117 of 2012. The petitioner stated that the present OP fraudulently obtained the signature of the petitioner on a Vokalatnama and some demi papers. The petitioner was not aware of the TS 117 of 2012. But from, my lord, this is very important portion. From
Which
the
petitioner? The present petitioner.
petitioner,
That is the plaintiff.
Plaintiff,
Yes,
petitioner means the plaintiff. Is the plaintiff.
petitioner means, my lord, from the record it appeared that the present petitioner appeared on 29 September 2012 and it was ordered to proceed the suit ex parte against the defendant number 1. She was present in the court, my lord.
Lordship, that is my case at
Well,
all.
what is your application?
Lordship, that is my case, Lordship. That is, Lordship, that is my case, Lordship. The wakalat, my brother has taken wakalat, taken my signature in a wakalat.
What is your have you annexed this application?
Lordship, kindly come to the affidavit I have sworn in before this honorable court, page 14, my lord.
No. The application before the trial court. Which page?
My order and rule 13 application.
Yes.
Order and rule application to me.
And
No, my lord, that is not lying with me. But Lordship, the affidavit in chief, a copy of the affidavit in chief filed by me, Lordship, in the order and rule 13 proceeding, kindly page 14, my lord. Page 14 of the petition. Lordship, that is my case. If it clearly, no, she was.
Can she claim that she
It
has
doesn't
no
mean
knowledge
that she is
about-
present. Lordship,
The cross-examination of this person was done.
Who is advocate has to be through.
What is the cross-examination?
Lordship, kindly come to paragraph 4, Lordship, on the page 14. My lord is on page 14. Paragraph 4. The opposite parties come to my place and ask me that my father executed a deed of gift which must be confirmed in the court. Otherwise, settlement of record of ROR could not be prepared. Trusting the version, I execute signed Vakalatnama along with some blank demi papers, and thereafter I handed over those papers to my brothers and sisters, Lordship. This is my case. Now the Vakalatnama is with them. I trusted them. And they may have an advocate and
paragraph number 14.
Okay. And which other paragraph?
Lordship, 4 and 5, Lordship.
Kindly come to paragraph number 14, my lord. Of the
Paragraph number 14.
Yes, my lord. There also she stated, when I have received a notice on 4th September 2014 from the BLLRO office, I have had suspicious regarding the matter
That is
and by
passing
taking
of
the
the
advice of...
decree. That date is after.
Just a minute.
And my lord, she has obtained the certified copy of the decree on...
After passing of the decree, everything is after.
When?
August 2014.
That is also after passing of the expiry decree.
Yes, my lord, but
No.
every knowledge...
09
After
2000.
passing of the decree, I have knowledge.
09 2014 is the notice received.
Yes, Lord.
And certified copy, when did you receive?
In the month of August, Lordship.
Where have you
In
stated
the
that?
month of Lordship.
Kindly come to page 18, my lord, in top portion. 22nd August 2014 was certified copy was ready for...
All the dates are after passing of expiry decree, not at all within the pending of the suit, Lordship. The decree has been passed in the March 2014, Lordship.
My lord,
Decree has been
there was
expired. Decree has
also
been passed
recording
in May
of
in the
the
March
trial
2014. I
trial
had no
court, my
knowledge
lord,
till
that
that
the
time.
petitioner was
I had knowledge
appeared.
after
Petitioner has
the
appeared
decree
in
has
the
been passed,
matter.
Lordship. That is my case, Lordship.
Petitioner has appeared in the matter.
Not at all.
And kindly come to page 30, my lord. Trial court has recorded, my lord.
Without hearing me, my deed of
Petitioner has
gift has been
appeared,
cancelled,
my lord,
Lordship.
in the court.
Page 30.
Yes, my lord. Trial court had recorded, my lord. From the record, it appeared that the petitioner had appeared on 29th September 2012. my lord.
With the
Petitioner had appeared, my lord, before the court. Petitioner had every knowledge of this.
Now the question is, was this Order 9 Rule 13 taken up on evidence or simply seated on affidavits? Any cross-examination or anything done? On evidence it was taken.
No cross-examination as I have.
No. Question is, you see, this Order 9 Rule 13 applications or this whatever it is, these are taken up on evidence. So opportunity to cross-examine is usually granted. Was that
I
done?
will file my chief, Lordship, but
Definitely. So they can cross-examine you.
I have been told by that cross-examination was not there.
Cross-examination was not there.
Lordship, my learned friend can
My lord, I
enlighten
have
that.
to take instruction, my lord, whether cross-examination was done or not.
Whatever I have stated or not, Lordship.
No, but what is their stand?
Lordship,
Anything contrary has come in the cross-examination.
Lordship, that is not there in the judgment order.
Yes, record an order. Anyway, take instructions.
Yes, my lord. Let them
Learned
take
advocates for the parties are present. Heard learned advocates. Let this matter appear for further hearing. When can you take? 13 or 20th?
20th, my lord.
20th July 2026. deeply honest. আর পরেরটা রেখে দিন একটু জাস্ট হ্যাঁ দেখি খানিক না ফিক্স ম্যাটারটা একটু পরে ধরা হবে রিভিশন তো সপ্তাহে অন্যদিন নেওয়া হয় না বুঝতো
না এসব বলছে যে নিও না নিও
ঠিক আছে অন্তত 12:30 অব্দি দেখা যাক আর কি 12:30 পরে ধরে নেওয়া ইয়েস
Hello, item note 22, my lord. Preemptive is the petitioner before lawsuit. My lord, section 8 application was allowed by the London trial judge holding that the co-sharer has filed this application holding there was two suits. My lord, initially, my lord, what happened, my lord? The coach, my clients are
section you are the
I'm the preemptive. The section 8 application was filed by
section 8 was allowed
by the London trial judge.
But the appeal court set aside.
Appeal court set aside on the ground of adjoining ownership and on the ground of co-sharer. They have said even if the demarcated portion has been sold to the co-sharers, my lord, they remains a co-share. Well, our specific stand before the London trial judge when the common vendor transfers the property, demarcating the
Anyway, other side is not here.
We have served and handed up the every service, my lord. What I was praying, my lord, we have filed an application for extension of interim order.
Anyway, record an order.
Interim order.
Learned advocates for the petitioner is present, none appears for the respondent, opposite parties. However, in the interest of justice, the matter stands adjourned till 20th July 2026. Learned advocate for the petitioner is requested to serve one more notice upon the opposite parties. Let this matter appear on the said date. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
I am grateful, dear Lord.
Service.
Hello,
The affidavit of service file we kept with the record.
কবে আসবে বল না 5 weeks only interim order.
Serve one more notice.
Yes.
In this matter, I have the instruction to appear on behalf of the opposite party number 226, 7A to 7G and 9 to 17. On the last occasion,
23.
last occasion on 21st of April,
direct
2025. My Lord Justice,
affidavit of opposition filed in within 2 weeks. Reply within 1 week thereafter. Matter will appear on monthly list of May 2025.
What is this order under challenge?
I'm challenging the order 6 rule 17.
Lord, this is the affidavit in opposition.
Opposition has
So you have challenged order 6, rule 17.
Order 6 rule 17. Lord.
Let us see this order.
Affidavit in opposition today has been filed, not been served upon me.
Affidavits will be considered, but the in revisional application, you see, the amendment petition was allowed. That you are challenging.
Not been allowed. That
Not
was
allowed.
challenging before this court, Lord.
Okay, let us see the order.
Kindly
The
25th July 2018, Lord.
Let me see.
Fact of the matter, Lordship.
After page 96.
At the time of discovery, no document has been produced. In spite of due diligence, plaintiff have got a deed in the year 2017, 21/11/2017.
Page 96.
After page 96.
Yes, after page 96.
Impugned order.
Impugned order 24th July 2018, Lordship.
24th July.
Have you got it, Lordship? 24th July 2018.
What is the nature of the suit?
Suit for declaration and permanent injunction, Lordship.
Yes.
24th July 2018, Lordship. Third paragraph. I have heard the submission, learned counsel for parties perusing amendment petition and the other materials on record, I find that the case record, the defendant have mentioned about the registered deed number such and such in their written statement dated 13/2/2012. This is a false statement, Lordship. Thus, the plaintiff came to know about the sale deed number such and such year 2012, and the plaintiff have filed this amendment petition in the year 2017. The Article 54 Limitation Act provides that the limitation period to challenge the registered instrument is 3 years from the date of knowledge. Therefore, the plea of challenge to the registered sale deed number such and such is barred by limitation. Further, the plaintiff have filed an amendment petition after commencement of trial of the suit. Moreover, the plaintiff could not show the plaintiff could not raise this matter before the commencement of trial, dispute their due diligence. More so, defendant would be highly prejudiced. It is instant application petition is allowed at this stage. Hence, this order amendment petition of the plaintiff is rejected.
No, what was your petition?
Lordship.
Your petition before the trial court?
Lordship.
May I just submit one?
Yes, yes, yes.
But the application itself is defective.
Lordship,
Yes, where
Lordship,
is that
kindly see
application?
page, kindly see.
No, no, which application, which page?
The revisional application is defective.
Yes.
No, Lordship.
Because not the opposite party number 18 died in the year 2011, but made party here. Number 8, opposite party number 1, number 8 has died 13/2/2019.
Already it has been,
Number
Lordship.
9, opposite party number 9 died.
It has
in
already been recorded in the lower court record, Lordship, and their name has been expunged, and subsequently party has been substituted. Thereafter, Lordship.
Okay, trial court, this recording
Yes,
is done.
yes, yes.
During the pendency of this
Pendency of-
application.
Lordship.
No. Your opposite party number 1 died in the April 2020. Then the petitioner number 2 died just before the pandemic. Petitioner number 3 died in 2019.
After
So you
pandemic,
can take-
this
you can-
case is pending before this
That is
court,
why
Lordship.
indicated
How
in
can
my
I correct
petition,
in this
I have
petition?
made the
In the
opposition
court below, they will.
file the reply.
So it's better you take steps to bring the heirs on the record.
Lower court,
Absolutely defective application.
we can pray before this court below to incorporated this name and
But let it be,
substituted in this
let it,
name of
let
the
it, no,
legal
no,
heirs
no.
of the deceased.
Lower court, trial court, it is there, okay?
Lordship.
So you take steps in this court also. You come with the necessary application. Yes, record an order. Learned advocates for the parties are present. As necessary steps are to be taken to bring the heirs of the deceased opposite parties on record.
Kindly supply me the name and address of the
The
legal heirs
matter
of the
stand
deceased.
adjourned to enable the petitioner to take necessary steps. The learned advocate for the opposite party is requested to furnish the particulars with regard to the heirs of the deceased opposite parties.
Lordship.
I said, let them file the reply also to the affidavit in
Not
opposition.
been supplied
That will
to any
be
opposition,
that will
Lordship,
be
till
taken
now.
up at later stage. First, let them substitute
Lord, I have filed the opposition. Kindly
the affidavit in opposition filed to this revisional application be kept with the record. Let this matter appear on 20th July 2026. In the meantime, you take steps.
I will take steps also after providing such documents. Otherwise,
I am giving you 3 weeks time. Definitely, in the meantime, you will supply.
Lordship, in the meantime, give a opposition, Lordship, give a direction to send me.
আমি বললাম যে কপিটা দিয়ে দেবো তোমাকে।
ঠিক আছে, ঠিক আছে। Great, Lordship.
But 24 and 25, both are connected matters. Today, the matters are appearing that the restoration applications are pending. There are 2 applications. One is for restoration and can 2 is for section 5 application.
You are for the petitioner.
I have to serve.
Okay, record an order. Learned advocate for the petitioner is present. Let copy of the restoration application be served upon the opposite party.
Along with section 5.
Along with section 5, let this matter appear on 13/7/2026.
Next one, same. Connected.
Both 24/25.
In this matter means Mosumi Bawal appearing for the petitioner. Your
Okay, not today.
Lordship, kindly make it not this week.
Yes, yes, not today. Okay, not today.
Sir, sir, I am the intern of the advocate Kosto Banerjee. So, sir, he is the engaged in another court. He is the petitioner of the case, item number 27 and 28. So, sir, please kindly give a 15-minute passover.
Not today করেছে তো
No, are you appearing in this matter?
No, sir. I am the
Lordship,
intern of the.
So,
I am appealing for the opposite parties, my lord.
Okay.
already not today. No, 27, 20. He is praying 27, 28.
27, 28. Okay, not today.
Already not
My
today.
lord, my lord, my lord, my lord.
I am for the lordship's petitioner. ছেলেরা শুনবে না কিছু।
Yes, this is for revisional application.
Lordships, Lordships, I have challenged the order. Lordship, order dated 30.
So service is complete.
Yes, Lordships. The last question, learned advocate is appeared, Lordships.
But today is not appearing. Okay.
Then not today.
Okay, not today.
All right. 29.
30, my lord, I am for the petitioner.
This can applications for what? Can 1, can 2?
My lord, matter was dismissed for default, my lord. I filed restoration application.
Service complete upon the opposite parties? Service of this restoration application is complete upon the opposite parties?
No, my lord, matter was dismissed in the under the heading listed motion, my lord. First, no caveat was there.
When it was dismissed?
It was dismissed on 24th June 2024. And
After how many days you have filed?
My lord, there is a delay of, my lord, for 52 days.
So you serve and come. Can 2?
Yes, my lord. Can 2 is the, my lord, section 5 application.
So let the copy of this application be served. Yes, record an order. Let copy, learned advocate for the petitioner is present. Let copy of this application under section 5 of the Limitation Act and the application for restoration be served upon the opposite parties. Let this matter appear on 20th July 2026.
My lord, in this matter, my lord, I am appearing for the opposite party.
May it please your lordship, my lord, in item number 31, I am for the petition.
My lord.
Lord,
your application can 2.
No, can 2. No, no, can. All can, as my lord, dispose of.
it's a civil revisional application of 2020, my lord. Seven six. Can 2. But what happened in this matter? May I submit, my lord?
Let us see the order under challenge, this revision.
It's the appeal court's order. But the appeal court's order dated 25th November 2019.
Can 2. Can 2 order is passed. Can 2.
But the restoration unit.
Restoration application.
Restoration.
না সেটা ঠিক আছে কিন্তু can 2 তে কি কোনো order হয়েছে? Yes, any order is passed on can 2.
My lord,
I think it is
so far my
restoration.
My lord, I am for the opposite party. The matter was time to time, my lord, dismissed for non-prosecution, my lord, and restored. I think the last.
Yes.
Already restored.
So 12/6/2025.
My lord.
It was restored.
My lord.
So you are aggrieved by this?
Lord, the order of the appeal court in which, my lord, the appeal is allowed and allowing, my lord, the defendants and opposite parties application under order 9 rule 13. Lord, what happened in this matter?
No, Order 9, Rule 13. Okay.
My lord.
Order 9, Rule 13
Was allowed, my lord.
in this appeal.
In the appeal, my lord.
Okay.
There was an expertise decree, my lord, against me. This is arising out of the eviction suit, my lord.
Yes.
We could not appear. I filed the application under Order 9, Rule 13.
But that is not a correct
that was dismissed, my lord.
submission.
Yes,
That
Order
cannot
9, Rule 13 was dismissed.
My lord.
It was
Okay.
allowed.
No, dismissed.
In the trial court.
By the trial court, it was
Order
dismissed.
9, Rule
Thereafter, my
13
lord,
was
allowed by the
dismissed.
appeal court.
Against that, you preferred an appeal,
Allowed.
and the appeal court has allowed this.
My lord, against that, my lord, they have come before your lord.
The present revisional application.
Yes, let us see the order.
My lord.
My lord, kindly see.
Trial court order. तरह से कोई जजमेंट अवर कोई तरह से एडवोकेट কথাটা লেখ সুধীর সাধুকা এই যে ব্যাকসিট থেকে লেখা
চেঞ্জ নিয়েছে আমি জানি না।
না আমার বড় বলাই দিয়ে দে সবার লাস্টে দিয়ে দিল
সাধুকা ছিল
অ্যাকাউন্ট রেকর্ড আসছে বলতে কিন্তু কপি বার করে দিয়েছে আবার করে কোন প্যারাগ্রাফটা দেখা দেখেন তারপরে সুপ্রিম কোর্টের জাজমেন্ট গুলো দেখা যাবে সব দুটো করে সিপিসিটা উপরে রাখো 9:30 ও এই নাম দিয়ে দিয়েছিস এর নামটা দিয়ে দিয়েছি
নাম দিয়ে দিয়েছিস এবার ভালো কন্টেস্ট হবে
চলে গেছে
petitioner.
Yes.
But what happened in this matter, my lord? Initially, the suit was filed in long back in
You are the
1985.
plaintiff.
My lord. I am the plaintiff petitioner before your lordship. Lord, long back in the year 1985. Thereafter, my lord, summon was served. The defendant, upon receiving the summon, appeared in the suit, filed their written statement, filed applications under 7.2 and 7.1 and 7.2 of the West Bengal Premises
1956.
1956, yes. 1985 suit. Thereafter, what happened, my lord? The 7.1,
So this suit is under the old act.
Yes.
Under the old act, my lord.
Okay.
1956 act. Lord, thereafter, the 7172 application was dismissed. Challenging that dismissal, my lord, a civil revisional application was filed by the defendant in the year 1992. My lord, the revisional application was admitted and there was an order of stay of all further proceeding in 1992. Lord, in the meantime, during the pendency of the suit as well as the revisional that revisional application, in 1999, my lord, the amendment came. Amendment of City Civil Courts Act
Enactment of
and
new
the Small Cause Courts Act as well. My lord, by virtue of that amendment, my lord, and the Gazette in the Gazette notification, the amendment was published, and by virtue of that amendment, my lord, there was a change, my lord, in the pecuniary jurisdiction of the courts, and this particular suit, ejectment suit, my lord, it went to the Presidency Small Cause Court. It has to wait. My lord, the defendant, my lord, filed an application for put up in the year 2000, and during the pendency of that application, my lord, what happened, my lord, that there was an order of stay, and the learned court below, the trial court, awaiting the High Court's order. That's why no administrative order of transfer was passed. My lord, up to this, my lord, the defendant is well aware and active so far as the present suit is concerned in the lower court as well as before the Honorable High Court. Thereafter, what happened in the year 2001, Lord, the revisional application was dismissed.
My lord, I am
My
interested.
lord, may I complete my submission?
Yes.
Then my learned senior friend will carry. My lord, it was dismissed. After this dismissal, my lord, in 2006, the plaintiff and the petitioner before your lordship, my lord, put up the matter, and my lord, apprised the learned court regarding this dismissal of the civil revisional application. Thereafter, by way of an administrative
Which
transfer,
court? City Civil Court or Small Causes?
my lord, City Civil Court. The matter was pending before the City Civil Court. After the dismissal of the civil revisional application, my lord, it was, my lord, intimated to the learned City Civil Court, upon which, my lord, by way of an administrative order of transfer, the suit was transferred to the Presidency Small Cause Court. Thereafter, my lord, since then, the defendant, my lord, chose not to appear.
How many days the defendant did not appear, as per the record?
My lord,
That
how many days?
From the evidence stage or from the argument stage? What stage?
From the evidence stage, my lord.
Evidence stage of whom? Plaintiff or the defendant?
Evidence of the plaintiff, my lord.
From the evidence of the plaintiff.
And 6 dates, my lord, were exhausted, and thereafter, my lord, an ex parte decree was passed.
So, have you annexed those records? So 5-6 days the defendant did not appear.
My lord, my lord. Order decree বার কর। I'm showing your lordship. এইগুলো কেন লাগিয়েছিস?
ঠিক আছে, এ তো অর্ডারের মধ্যেই বলা আছে, তাহলে
এটাই এটা কোথায়? ডিগ্রিটাই পাবো। তাহলে ডেট গুলো কি করে পাবো? দাঁড়া, the lordship will find at annexure P2 at page 20, my lord. All orders এখানে দিতে হতো। দাঁড়া দেখা ইন্টারফেস করছি।
Yes.
এটা কোন কোর্টের অর্ডার?
Page 20, yes.
My lord,
This is the order of the small cause court,
designation
my lord.
not marked, my lord, in my copy service.
The order dated 17.
Order date to copy.
Lord, it appears that I'm placing, Lord. It appears that the plaintiff filed the present eviction suit against the defendant inter alia on the ground of reasonable requirement, defaulter, etc. The defendant appeared in this case and contested the same by filing written statement.
17/11/2006.
My lord.
This decree, ex parte decree was passed.
My
and the application for setting aside, on which date it was made?
In 2011, my lord.
2011?
No, 2000.
2008, ex parte decree was
No,
made.
2006.
2006 or 8, whatever. And we came to know in 2011. My lord, I will
That
come.
is also not a correct submission.
Yes, yes.
Lord, initially the defendant resisted the belief from taking possession.
Okay,
Long back in my lord,
okay,
2006.
so that was condoned, 2011. On the ground of knowledge, that delay was condoned.
My lord, no. Section 5 application was
Yes,
my lord,
I
filed along with.
Section 5 application,
No
as well as the
reflection is there
application
from
on
the
Order 9 Rule 13, my lord. Everything is
Yes,
finally
yes,
in appeal
condonation
for
of
all
delay.
allowed.
Yes, it is here, page 29.
Yes.
দাঁড়াগুলো দরকার নেই। সব অর্ডার গুলো আনিস।
It is for condonation of delay, my lord. Page 29, prayer. Everything will.
Lord, my humble submission before your lordship is, Lord, the defendant is well within the knowledge of the entire proceeding. Lord, then what prevented the defendant, Lord, when it is also within the knowledge of the defendant that, my lord, this regarding the amendment of 1999, and subsequently defendant, my lord, did not appear in the suit, and my lord, filed an application under Order 9 Rule 13, showing that sufficiently prevented from appearing. My lord, my humble, so far as the present case is concerned, my lord, it is not a sufficient cause for which, my lord, the defendant was prevented. My lord, may I place, my lord, Order 9 Rule 13 once, my lord.
Civil procedure premises transient. It makes the near.
My lord, so far as the present matter is concerned, my lord, no further notice is required, and that is well settled.
Yes.
I'm placing, my lord, Order 9 Rule 13 once.
Anyway, that is there, that will be considered.
My lord, I'm relying, my lord, two judgments, my lord. One is, my lord, 2017 for ICC 435 Calcutta. 435 Calcutta.
Yes.
Okay. Urmila Jalan versus Tulsi Devi. One paragraph. But I'm placing para 13, my lord.
Anyway, you just hand over the copies.
My lord.
I shall consider.
My lord, para 13, 14. My lord, in para 14, my lord, I'm just placing only one sentence. In view of the above, there is no mandatory provision that the party is required to be informed also in case of transfer of the suit or case
Anyway,
from
that was
to another
considered by
party.
the
Yes.
learned judge.
And my lord, I'm relying on 2011 3 Supreme Court cases, page 440, 545.
445.
545.
Oh, 545.
Lord, here, my lord, para 13 onwards is relevant. Lord, if your lordship kindly permit me to place para 13 onwards. That sufficient cause is an expression which has been used in a large number of statutes. The meaning of the word sufficient is adequate or enough in as much as may be necessary to answer the purpose intended. Therefore, word sufficient embrace no more than that which provides the platitude which, when the act done, suffices to accomplish the purpose intended in the facts and circumstances existing in a case and duly examined from the viewpoint of a reasonable standard of a cautious man. Lord, I am pausing here for a moment, my lord. My lord, the reasonable standard of a cautious man means, my lord, the due diligence that is elaborated in the judgment itself. Where is the due diligence of the defendant? When the defendant's, my lord, he was well within the knowledge regarding the entire proceeding. Thereafter, my lord, the acting diligently, this is lacking. Lord, however, the facts and circumstances of each case must afford sufficient ground to enable the court concerned to exercise discretion for a reason that whatever exercises discretion, it has to be exercised judiciously. And my lord, para 16 is most relevant. In order to determine the application under Order 9, Rule 13 CPC, the test that has to be applied is whether the defendant honestly and sincerely intended to remain present when the suit was called on for hearing and did his best to do so. Sufficient cause is thus the cause for which the defendant could not be blamed for his absence. Lord, here, if the defendant is absent, Lord, I am putting a question to myself, who is to be blamed? The defendant himself. Therefore, the applicant must approach the court with a reasonable defense. Sufficient cause is a question of fact, and the court has to exercise its discretion in a varied and special circumstances in the case at hand. There cannot be a straitjacket formula of universal application.
Very well.
My lord, here there is, Lord, paragraph 11 onwards. In this judgment, from the 11, in paragraph 11, it set out the provision of Order 9, Rule 13, 11, 12, 13, 14, 15, 16, 17, 18, and 19.
Yes. That's all.
My lord, may I sum up in this way, my lord, that when to get any aid under Order 9, Rule 13, Lord, there has to be, Lord, the defendant has to, Lord, act diligently.
You see, reasons is assigned by the appellate court, okay?
My
so
lord.
if this court
Lord,
finds that
the reason. Why, my lord?
Yes, if this court finds that it is perverse, then that order cannot be
My lord,
sustained.
on the basis of only one fact, that after the transfer, my lord, your lordship, it is reflected from the
Very well. You see,
judgment of the appeal court, which
suit
is the
was
order
pending for
entered
a
before
long
your lordship.
period.
My lord, suit is pending since, my lord, 1985. My lord, thereafter, my lord, on only one ground, this appeal was allowed.
Very well. If that is
the
sufficient.
only ground that no further notice was given to the defendant. My lord, my humble submission before your lordship is the so far as the present matter is concerned, no further notice is required. This is my one limb of argument, and my another limb of argument is, my lord, the defendant lacks its due diligence, my lord.
Anyway, the judgment was considered by the learned judge. The judgment of this court was
that is-
considered.
yes, my lord.
Anyway, let us see. We shall consider the factual aspect also.
The Supreme Court judgment.
My lord, the honorable, my lord, appeal court, my lord, also considered the records of the case and also considered the evidence. From those evidence and the records, my lord, it has been crystal clear that no notice, no knowledge about the transfer, as well as, my lord, the new number of the suit was predicted, my lord, that was not within the knowledge of this case, my lord. My lord, there is a judgment, my lord, whereas, my lord, page 9 of the judgment, my lord. Page
Anyway,
9.
No, are you relying upon any judgment?
My lord, yes, I am relying, my lord, but on the next occasion, my lord, I will give all the decisions, and as well as my lord, I will consider their judgments to distinguish all these things, my lord.
And my lord, this
because if your lordship
3SCC was not considered by the appeal court.
Yes, because, my lord, I have 7 and 8 judgments, my lord. I will compile it and I will hand over to your lordship on the next.
Record and order.
Okay.
Learned advocates for the parties are present. Heard learned advocates. Let this matter appear for further hearing on 13/7/2026.
20th, my lord. Kindly.
Yes.
20th, my lord.
20th
July 2020.
My lord, 20th July I will not be
13 available. 20th.
Then 27th.
27.
27/7/2026.
27. 27. And I will come with the, my lord, all compilation, my lord.
May I also come back with a written notes, my lord?
Ajay, call the next matter. Just next matter ta call kore din.
I'm grateful to you.
হ্যাঁ না ওই ম্যাটারটা এটা কত 13 হলো তো
31
সবগুলো কল করে দিন ঠিক আছে আমি দেখে নিচ্ছি
31 হয়ে গেছে
My lord, there was an order saying that is order dated.
See,
December
service is complete.
2019, my lord. Yes,
Other side is not here, you see.
my lord,
স্যার
in person, she
আমি আজকে আমার অ্যাডভোকেট উনি আজকে হঠাৎই উনি অ্যাবসেন্ট ওনাকে বাইরে যেতে হচ্ছে একটা খুব আর্জেন্ট কারণে তো স্যার আপনি যদি পারমিশন দেন স্যার আমি কি কিছু বলতে পারি মানে
Anyway, record and order. Learned advocate for the petitioner is present. As time is sought for on behalf of learned advocate for the opposite party, the matter stands adjourned till 13.
it can be extended, my lord. The extension order can be given, my lord. It
No,
can be
13/7/2026. The interim order passed earlier stands extended for a period of 3 weeks or till further orders, whichever is earlier. Yes, adjourn করেছি 2 সপ্তাহের জন্য 13 তারিখে থাকবে।
ঠিক আছে
Online,
33, my lord, I am for the opposite party bank. 33, my lord, I am for the petitioner. And on the last occasion, when your lordship was taking up the matter, your lordship inquired of the bank whether they were willing to go for mediation or not. My lord, we were ready. Now, my lord, on the last occasion, Mr. Mukherjee was not appearing. My lord, I understand that there's been a change of the advocate on record. But this is what I've understood, my lord.
So take your chance in mediation.
I tell your lordship, my lord, in this case, my lord, the mediation is not possible. Why I say? But my learned friend, before, my lord, the DRAT took out an application for impleadment as a party. But he had a dual role to play. At the time of taking the loan, my lord, he was the director. He thereafter, my lord, resigned as a director. And he is also a guarantor in respect of, my lord, this particular loan.
Now you resolve the matter.
But the resolve is against, my lord, that he is no longer the director. He's a guarantor.
All parties
So I can
be,
take his property, my lord.
no, all parties can be called in the mediation proceedings. Okay.
But all parties are not before your lordship.
No, but in the mediation proceedings they can be called.
Lord, I would rather say that your lordship will kindly hear the matter on merit because Lord, before the DRA team, Lord, the matter is pending since 2016. I am the bank. Lord, there is a lot of outstanding as against this particular loan.
Very well. In the mediation, it is an easier way to sort out rather
But
than.
then, my lord, kindly, my lord, also, my lord, direct, my lord, the other parties to be present before your lordship on the next day. Thereafter, your lordship decides.
Who are the other parties?
Because, my lord, he is only seeking addition of party, my lord, in the DRA.
Yes, my lord. The other
Achha,
party.
record and order. Learned advocates for the parties are present. As
So, my lord, kindly have a look into
as
the.
for the purpose of settlement, all the necessary parties are to be brought on the record.
But 3 and 4 particularly.
Learned advocate for the petitioner is requested to cause service of the notice and the application upon
3 and 4.
Upon respondent number.
Opposite parties number 3 and 4.
Respondent opposite party number 3 and 4. Let this matter appear on 20th.
As early as possible.
20th
There
July
will be a
2000, 20th July 2026.
But even before that, your lordship will send it to mediation. But I am.
No, whether service will be complete prior to 20th.
They are in Middleton
আচ্ছা
Street.
20 তে আগে ওটাকে 13 করে দিন।
Netaji Subhash Road. Sorry. 13 তারিখে 13 তো একটু প্রবলেম আছে।
Then 20th.
As your lordship pleases.
তাহলে 20।
I'm so grateful. Thank you.
Much obliged.
Lordship, item number. Lordship, I appear for the petitioner. Lordship was hearing this matter at length. This is a civil revisional application which was specially assigned to your lordship against an order dated 20th November, your lordship, 2025. Your lordship, the interim order had expired on 5th of May, and the matter was due to be heard by your lordship on 4th of May at 10:30 a.m. Thereafter, the matter has not been taken up by your lordship. Let the interim order be extended and date be fixed, your lordship, for completion of the hearing.
So I'll take it up next Monday.
Lordship, let the interim order be extended.
Yes, record and order. Learned advocates for the parties are present. Let this matter appear on 13/7/2026. The interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
Lordship, if your lordship kindly fix that time.
Yes.
In the morning, first. At the first sitting, it will be taken up.
Let that be at least in the top of the civil revision
It
matters.
will be taken up. You see, civil revision matters are taken up on every day, on Monday.
Grateful, your lordship.
My lord, I beg to appeal for opposite parties that the petitioner is appearing in person and he sees that appearing, my lord. Matter has been declared in the court more than 6 months ago.
Okay, just a minute. Yes, record and order. Learned advocate for the opposite party is present. None appears for the petitioner. Learned advocate for the opposite party submits.
Supplementary affidavit when I submit.
Files an affidavit.
Why
States that the suit has already been decreed. In the facts and circumstances, learned advocate for the opposite party is requested to serve a notice. Any petitioner is happening in person or through advocate?
In person. She has been provided amicus curiae, but she refused.
Learned upon the petitioner or the learned or his learned advocate. Let this matter appear on 27/7/2026 as the last chance.
27th?
7.
Grateful. Can you accept it, my lord?
The affidavit filed be kept with the record.
Supplementary affidavit.
Yes, call the fixed matter.
No, prior to the 10:30 মার আছে।
Yes, 12 noon fixed matter.
So 10:30 matter will take up 2 p.m.
Just a minute.
করবে কিন্তু।
My lord,
এখন করে দাও তুমি ওটা। 5 মিনিট হয়ে যাবে ওটা আমার। আমারটা হয়ে যাবে। তুমি 10:30 করো আমার করে দেবো।
Anyway, you serve a notice, I shall hear you. I made it as a last chance.
আদাসের আছে আমার। তুমি দাও ওটা।
Yes.
তুমি দাও না ওটা আমি করে নিচ্ছি। আবার আমি কুদিয়ে করে নিচ্ছি। কোনটা করবে?
আচ্ছা।
10:30 matter will be taken up as 2 p.m. lordship.
Anyway, both parties are present. I'll take it up.
2 p.m. Both parties are present, lordship.
My lord, on behalf of Drijodas Chakraborty, I pray for adjournment.
I am for the applicant. Today is the third time it is specially fixed, my lord. I am ready for hearing. Today is the third time. They may file written argument, my lord. I can argue my. Today is the third day.
You record an order. Learned advocate for the. You have concluded your part.
No. The first time I will argue my.
Learned advocate for the appellant is present. A prayer for time is made on behalf of learned advocate
for railway
for the respondent railway authority. let this matter appear on 27/7/2026 at 12:30 p.m. as a last chance.
That's it.
But I am for the respondent with Mr. Guddu Singh.
My lord, I am for the applicant. My lord, it's a very small issue. It will take only 10 minutes, my lord. Only regarding interest, my lord. My lord, only regarding interest, this case was already awarded. Kindly, my lord, come to page number 83 of the paper book.
We can quantify death cases.
83. Yes, this is the judgment.
The judgment date of decision is 29/12/2025. Now, you will kindly come to the order portion, page number 93. Page number 92, my lord.
Yes.
The application is allowed for rupees 8 lakh on contest in favor of the applicant along with interest from date of order till payment, not from date of accident. It is order from date of order till payment. So only for that I have filed the appeal, my lord. Regarding this interest thing, my lord, I am filing the judgment of Supreme Court. This is Reena Devi judgment, my lord. I've got it. হ্যাঁ আপনাকে দিয়ে দিচ্ছি বলেছি regarding interest, my lord, in absence of any specific statutory provision, interest can be awarded from date of accident itself when liability of railway arises up to the date of payment without any difference in stages. Legal position in this regard is at par with cases of accident claims under Motor Vehicles Act 1988. So this is Reena Devi judgment of Supreme Court, and this is the latest judgment of Bombay High Court. This is the latest judgment of 12 June 2026, just 10 days back judgment. In this, regarding interest, everything is clear. You know, last page number, point number 29. This is the latest judgment. The Supreme Court in the judgment of Reena Devi in paragraph number 30 has held that interest will be payable from date of accident. Having regard to the legal position, which is held to be on par with claims under the Motor Vehicles Act, interest at 9% per annum, that is rupees 72,000, appears to be just and reasonable. It is well settled that section 124A of the Railways Act is a beneficial piece of legislation. The rules of 1990 are framed in exercise of powers conferred by the Railways Act. Taking into account the date of the award is 11/2/2022, which is subsequent to the amendment of the said rules of 1990 in the year 2016, has been revised to rupees 8 lakh. The date of incident is 5/1/2019, and the amount as compensation as claim on that date was 8 lakh. The award was passed by the tribunal on 3/12/2021. By that time, the compensation payable pursuant to the amendment rules was enhanced to 8 lakh. However, considering the interest from date of accident till today of rupees 8 lakh would be 5,40,000. The total amount as of today would be 13,40,000. So this is the thing. Only interest point, my lord.
Oh, here is 6% per annum was awarded. Okay, any?
No, 6% per annum from date of order, not from date of filing or date of accident. From date of order, it was awarded, not from date of filing or date of accident.
And if they fail, then 9%.
Then 9%. Not from date of filing or date of accident. From date of order, it was awarded.
So this is your this is the portion in which you are aggrieved.
Yes.
Yes. What you say?
In the memorandum of appeal, 2 grounds were taken.
One more. Sorry.
I believe appellant has abandoned that other ground.
No. What are the grounds?
No. One more ground is, my lord. Regarding that fixed deposit thing, Your Honor.
You see, there is a provision under the rules that
Yes.
the authority, the tribunal is empowered. That I shall not interfere.
My lord.
Now, my lord, so for the interest part,
regarding only interest point.
Right. My lord, kindly appreciate one aspect. Interest on a claim comes into question when there is a delay on payment of the claim. Now, when the claim itself is not crystallized, how the interest come into existence? That is a question I am putting to myself. Now, my lord, kindly see the date of accident when the application was filed. The date of filing the case is 19th June 2025.
and date of decision is 29/12/2025. Now, my lord, under the Railway Claims Tribunal, under the for the
No, date
death
of filing the case is 19/6/2025.
June, filed in June and disposed of in.
When did the accident take place?
My lord, it is in 2024, 7th May 2024.
Now, here you see, this is an interest pendency light from the date of filing of the case till date of payment.
And in compliance of this order, the railways has already.
Now, they have 6% from 29/12. That means date of the judgment.
order.
My lord.
Now interest pendency light, if the courts are empowered to grant interest
Courts are empowered
pendency
to
light.
go, but not from the date of, my lord, accident.
So what does the Supreme Court decision say?
My
You
lord,
see, if you consider Motor Vehicles Act from the date of the filing of the claim case.
But in this Reena Devi Supreme Court is saying from date of accident. And regarding this interest point, I have served the latest judgment of Bombay High Court also, that is 12 June 26. In that also, date of accident interest has been
my
granted.
lord, then I have to consider these judgments, and if it is factually distinguishable, I'll distinguish it. Otherwise,
No, date of how, because after 1 year from the date of the
filing of the case is
filing.
after 1 year, more than 1 year, my lord.
When liability of railways arises up to date, yes.
তুমি আমাকে একটা কপি দিও জাজমেন্ট। কোনটা বলছো? সুপ্রিম কোর্ট তো?
এটা সুপ্রিম কোর্ট, এটা লেটেস্ট জাজমেন্ট বম্বে হাই কোর্ট।
So is the amount deposited?
Yes, it is deposited, my lord. Amount is deposited in fixed deposit. Now, my lord, I have this judgment is a longish judgment.
No, para 18, that is there. Para 18, and this is para 29.
Yes, my lord, but that is discretionary. Here, there was a delay of 1.5 months, 1.5 year for filing the application, my lord. And there is no delay on the part of the railways, either in taking adjournment or the claims tribunal in adjudicating the matter. And immediately after the decision, railways has put the entire money compensation amount in fixed deposit. So it's a discretionary power, my lord. The language, as I understand. And my lord, in railway tribunal's case, the compensation is fixed. It is as per schedule. Whereas under motor vehicles compensation claims, that has to be calculated, that has to be quantified, or taking into consideration several factors. Here, the compensation is fixed.
The compensation, my lord, is fixed, but interest it can be awarded, Your Honor. I'm not telling anything about compensation. That is 8 lakh, my lord. That is.
There is an absence of statutory provision, my lord. So this is a discretionary power of the court. But my lord, my humble submission is the mutual conduct has to be looked into. There is no delay on the part of the railway authorities.
Yes, record and order. Learned advocates for the parties are present. Are learned advocates for the parties. The appeal. This appeal is directed against the judgment and award dated 29/12/2025, passed by the appellant, passed by the learned Railway Claim Tribunal, Kolkata bench in OA within bracket capital 2U stroke KOL col stroke 0075 stroke 02025. Stop. The learned tribunal by the judgment and award dated 29/12/2025 was pleased to award compensation of rupees 8 lakh along with interest from the date of the judgment till date of the deposit. Stop. Learned the appellant claimant being aggrieved by the judgment and award passed by the learned claim tribunal has come up with the instant appeal. Heard learned advocates for the appellant and learned advocate for the respondent Union of India. Peruse the materials on record. Learned advocate for the appellant submits that the learned tribunal erred in not awarding interest from the date of accident. Stop. Learned advocates further relies upon the decision of the Honorable Supreme Court in the case of Union of India versus Reena Devi in Civil Appeal number 4945 of 2018 and the decision of the Honorable Bombay High Court in the case of Srimati Urmila Shahu and others versus Union of India through General Manager. Learned advocate submits that in terms of the order of the decisions of the Honorable Supreme Court and that of Honorable Bombay High Court, the tribunal ought to have awarded interest from the date of the accident. Stop. Learned advocate for the respondent Union of India submits that there was no laches on the part of Union of India in conducting the case. Thus, the learned trial judge did not commit any error in awarding interest from the date of the judgment. Upon hearing the learned advocates and considering the decision relied upon, it appears that the Honorable Supreme Court has observed that interest can be awarded from date of accident itself when liability of railway arises up to date of payment without any difference in stages. Stop. Honorable Supreme Court further observed that the legal position in this regard is at par with cases of accident claims under Motor Vehicles Act 1988. Stop. As there is a provision to award interest pendency light in civil suits, and as per the observation of the Honorable Supreme Court, that interest may be awarded upon pursuing the provisions as provided under the Motor Vehicles Act 1988. This court is of the view that it would be just and reasonable to award interest from date of filing of the claim case till date of deposit of the compensation amount. Stop. Thus, this instant appeal FMA 224 of 2026 stands disposed. The judgment and award dated 29/12/2025 passed by Learned Railway Claims Tribunal, Kolkata in claim application number O capital A within bracket capital 2 small u stroke KOL stroke 0075 of 2025 stands modified to the extent that the appellants claimants are entitled to compensation of rupees 8 lakh along with interest at the rate of 6% per annum per annum from the date of filing of the claim case till date of deposit. Stop. This application This appeal stands disposed.
Payment should be deposited in the High Court
No,
registration.
deposit is already made. There's a statement.
That is made in rest of the amount.
The interest shall be deposited within 6 weeks, within 8 weeks from the date of communication of this order before Registrar General, High Court, Calcutta.
And
the claimants, appellants will be entitled to withdraw the deposit upon compliance of necessary
My lord,
formalities.
may I make one submission, my lord? Here, as per the statutory provision, the rules, the amount has to be deposited, the claims, because the interest is part of the claims now, it has to be deposited in a bank. So, the
Anyway,
fixed deposit already.
In appeal matters, I am directing deposit to be made before the registrar.
My lord, without any creating any precedence, my lord. Without
No, in all matters, I am passing this order.
My lord. ঠিক আছে আমি
I'm sorry, my lord, due to the displaying, not answering of this court and all over the court, my lord, I mentioned the matter was fixed on 22/6 Monday, but unfortunately, lordship is sitting.
Anyway, if it is no, it was fixed on 20. Yes, give it.
Item number 4 fixed matter, মানে এটা 2 p.m.
এটা কি সই করতে হবে? হ্যাঁ আজকে Means first. Yes, hence this appeal FMA 2038 of 2018 along with court 98 of so and so stands disposed. Judgment and award dated 4th April 2018 passed by Learned Additional District Judge 5th Court Barwan in MACC case number 54 of 2013 stands modified to the extent that the claimant respondent number 1 to 4 are entitled to compensation of rupees 31 lakh along with interest at the rate of 6% per annum from the date of filing of claim case till today. The appellant, Sriram General Insurance Company Limited, shall deposit before the Registrar General High Court, Calcutta, rupees 31 lakh, along with the interest at the rate of 6% per annum, within 8 weeks from the date of communication of this order. In the event compensation awarded by trial court is deposited, no further deposit be made. The claimant respondent number 1 to 4 are entitled to withdraw compensation of rupees 31 lakh along with interest at the rate of 6% per annum upon compliance of necessary formalities. Balance amount, if any, be returned to the appellant, including accrued interest.
Extremely grateful to your lordship.
Claimants are there, my lord.
Yes.
There is 6 claimants. Marriage got a not integer.
My lord, the amount would be disbursed to the claimant in the same proportion as it was directed in the award.
Okay.
There were 6 claimants, my lord, I am told.
So the amount is reduced, so the reduction to
My lord,
be
in the same proportion, my lord, the proportion, my lord, the percentage of, my lord,
oh, that should be maintained.
that should be maintained. Your lordship will kindly clarify that, my lord. Otherwise, they will
The
be in
proportion
difficulty.
indicated by the Learned
By the-
Trial Court be maintained.
Extremely grateful to your lordship.
Claimants are there.
Jerome,
And deficit court fees is already paid.
No, no, no.
no, no, no.
I've not received any amount.
Deficit, you see, in the trial
Deficit
court
court fees.
record that you are paid.
My lord, your lordship will kindly make it a mandatory line in all the cases, my lord. Deficit court fee, if any, my lord.
Yes, deficit court fees, if not paid, be paid forthwith.
Yes,
I've recorded that.
My lord, in that case, my lord, your lordship also, my lord, kindly take note when the lordship enhances the amount. Then also, my lord, court fees is required to be paid. Your lordship is not clarifying that.
Yes, yes, that is also. Anyway, in this case, there is no enhancement.
Yes, there is no, my lord, there is no.
Okay.
Grateful to your lordship. I'm obliged.
This matter I am paying for the union of
I appear for
along with
the-
my-
I appear for the appeal.
Yes, I'm reading out the operative portion. In the facts and circumstances, this appeal, FMA 1315 stands allowed. Judgment and award dated 8/2/2017 passed by Learned Claim Tribunal, Kolkata bench on so and so matter is set aside. Respondent is directed to pay compensation of rupees 8 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. The compensation amount shall be deposited before Registrar General, High Court, Calcutta, within 8 weeks from the date of communication of this order. The appellant will be entitled to withdraw compensation upon compliance of necessary formalities.
My appellant number, not only one, there are others. My
Appellants.
Appellants.
Appellants. Yes, appellants.
Yes.
Deeply.
দিয়ে দিতে হবে।
The grounds of the appeal is that, my lord, the appeal has been prepared.
There is a counter objection also.
Yes, Lordship.
Yes.
Page number 46, my lord.
Okay, let us see. Paper. What is this application? Can 3? Okay, I have heard this matter earlier. Okay.
Can see, Lordship, is the withdrawal of the awarded amount, so can we dispose
Okay.
of the
Now you see, there is delay in 28 days in lodging the FIR. That you have argued. And the monthly salary was considered as rupees 6,000 per month without document.
Without document.
And next,
Another main point is that, my lord, the ground number 3, my lord, the alleged offending vehicle involved in multiple accident, my lord.
ground number,
Grounds number 3.
ground number
Page
3,
number 46.
page 46.
For the memo of appeal.
Yes, the out of which?
Ground number 3, my lord.
Okay, in multiple accidents.
Alleged offending vehicle
Yes.
involved in multiple accident, my lord.
And where is that? Where is that?
Actually, my lord, is 11 accident case is pending with the National Insurance Company, my lord.
Now the case is, now the question is, in which paragraph of the written statement you have stated that?
But in written statement, actually, in trial court, my lord, that ground has not been
No, no. This is a
Yes, ma'am.
factual aspect. In written statement, have you stated that?
Yeah, that say 11 times, 11 cases pending with
Okay,
the
okay.
National Company, same driver, same owner, same witness in the charge sheet, my lord.
Anyway, in the trial court, these points were not taken.
No, my
not- Yes, next.
Remanded it back, my lord, for proof that a document is, my lord.
Yes, yes, next.
The document is bad, but that has not been.
Maybe case may be there, but what does the fate of those cases? Case was dismissed in the claims tribunal, earlier cases.
Pending, civil case is pending, my lord.
Maybe, but what, so pending.
Yes, my lord.
So all cases are pending, or 7 except this one.
You see, the document is that, my lord.
Maybe out of accident claim cases arose. How many cases are still pending and how many disposed?
11 cases pending, my lord, with the National Insurance Company Limited.
Acha, this is the
Same
vehicle
driver,
is insured.
Same witness, same owner.
So you will defend the case.
The question is, earlier, did you conduct any inquiry by issuing notice to this owner and driver?
No, Lordship.
Anyway, you are, yes, any other?
No, that control will be taken, my lord, with my that.
Yes, then fault of the victim?
Fault of the victim, another, my lord, that ground is that, my lord. You will also kindly see, my lord, PW1, page 16, my lord.
Page
14 to 16. Thank you, my lord. You will also kindly see, my lord, cross-examination, my lord.
Cross, yes.
Cross-examination, my lord, apart from me.
No, this is the eyewitness.
Yes, Lordship.
PW?
PW1.
PW2.
PW1.
PW2 is
PW1 is not the eyewitness. You are relying upon page 14.
It is the page 16, Lordship, the eyewitness. He is the charge sheeted eyewitness, Lordship. His name is appearing in the charge sheet.
Page 16 is the charge sheeted eyewitness.
Yes, Lordship.
Okay, now which cross examination you are relying upon?
Vehicle number is, my lord, 30 WB38Q. But here, my lord, the PW1 stated the number of offending vehicle is 7105.
Which paragraph? That is?
In cross-examination, my lord. The question, apart from my son,
Number
daughter,
14, cross-examination, second paragraph.
Yes.
Second paragraph, no?
Where from
Second
the
paragraph.
last
Second
line,
paragraph, last
the
one.
number of the offending vehicle 7105, but prior to that WB38Q not said. That is
Very
his
well.
submission.
She's not the eyewitness.
No, he is the
Not,
claimant.
he is the PW1.
Okay, and eyewitness statement?
Eyewitness statement, Lordship, will find on page 16.
Page 16. This is the chief.
Chief and then cross.
Yes.
Then cross kindly see that
18, page 18.
So these two witnesses were examined. Okay. Anyway, so delay and the monthly salary, and this is involved in 11 accidents.
That is beyond the record loss. The neighbor said so the learned.
The claimants are okay. Now the anyway, any witness examined on your side? And 6,000 is, according to you, is excessive. What was the occupation of the victim?
Vegetable seller. Lordship, accident took place 2018, Lordship. 17 March 2018. 2018, 100 rupees 6,000.
His claim petition,
with the
in his
bill
claim
number-
petition also he claimed that he used to earn rupees 6,000 per month.
Claim petition,
Claim petition, Lordship.
Page 1, page 1,
page
1,
Page 1, 6,000.
paragraph 6,
paragraph
6,
6.
rupees 6,000 per month.
Column number 6, 6.
Column 6.
Okay. 5,50,000 was claimed and compensation awarded how much?
Compensation awarded, Lordship.
5 lakh.
Lordship, 5,98,000. Page 42.
Yes, what is your ground of challenge?
My ground of challenge is,
One
Lordship,
point.
the learned tribunal.
Yes.
In his cross-examination, he claimed for a deduction for personal injury 1/4. But my learned tribunal granted 1/3. Actually, claim na
মুখে বলতে দেন আমাকে আমরা।
আমাকে একদম কভার করে দিয়েছে।
No, no, 1/3 was deducted.
Yes, the one of the claimant.
How many claimants are there?
Claimant is one daughter is married daughter and son is my major son. They are not dependent. No.
According to you, you see, wife is there. Minor is how many?
Daughter and son.
Wife.
Married daughter.
Okay, wife is
Major son.
there. Okay, one is married daughter.
They are not dependent.
Two married daughter.
Two married daughter.
And one major son.
Now, one is the wife.
No, Povitro, Digar.
Pushpa Digar is the wife, and recently Madhumita
Oh,
Digar
this is
the
the
daughter,
wife.
and Pavitra Digar, lesson number 3.
Oh, this is the mother, Pushpa Digar.
Yes, Pushpa Digar.
Oh, Pushpa Digar is the wife.
Wife.
And this is the daughter. So now complainant number, the claimant number 2 is the wife, the daughter.
Daughter.
Page 3.
Page 3. Yes. Number 1 is the wife.
Column number 20.
Yes, number 1 is the wife, widow.
Daughter, son, mother.
Oh, 4th is the mother. No, if consortium of 40,000 is added for the mother, it comes to about 6,40,000.
Lordship,
6,40,000.
Lordship, that part I actually leave to your Lordship because of Lordship awarded 1,10,000. So whatever Lordship will decide.
No, 1,10,000 is already awarded.
Not awarded. No, the future prospect also kindly come to the judgment. The future that the after deduction and Lordship kindly come to page 42. The Lordship will find out the breakup.
Yes, loss of income is there. What was his age regarding future prospect?
Age was 55, my lord. That's why 55 years.
And what was his occupation? Vegetable vendor.
Vegetable age is 50 years. So according to Lordship, the 10% future provision has to be awarded. But the learned tribunal did not awarded any on that score, did not pass any award.
His age was 55 years.
50 years.
50.
55 years, my lord. 51 to 55.
Where, which document?
That is their submission, Lordship, not my submission.
No, sir, 50 years, my lord.
Lordship, kindly from PM, Lordship, kindly page 34. Lordship will come to a second column.
33.
Page 34, Lordship.
34, yes.
Second column, Lordship will come. Second row.
Yes, 50 years.
50 years. Learned table consider 50 years.
And in your claim petition, you have stated 50 years.
The submission are advanced by the
So your twofold submissions are this future prospect not taken into consideration.
and
The deduction is
to be 1/4 and Lordship the division 1/4. In support of that, Lordship, why I am paying for, should kindly consider the judgment of the apex court where Lordship is elaborately discussed with the issue because of the who are the claimants. Claimants means the legal representative, and the legal representative, the term Lordship will not find from the MBA. There is no definition in the Motor Vehicles Act. Who is the definition of legal representative? So legal representative, that conception will borrowed from the Civil Procedure Code. That is section 2, subsection 11. This will where the legal representative, the term is considered. And the Supreme Court also, the observation of the Supreme Court is that the legal representative means section 2, subsection 11 of the Civil Procedure Code. So accordingly, the Honorable Supreme Court decided the issue according to section. So who are the claimant, what is their job, what they are doing, that is not the issue. If they are legal representative, so they will get the compensation.
Let us see that.
It's the pencil mark is there, let's consider.
You see, the question is legal representative means the persons who are entitled to maintain the claim petition. But if we follow the guidelines of deduction, you have to follow pronotiety. Whatever is there, whether it is legal representative or dependent, what is the language there?
Sorola Bharna, my lord, clearly stated on dependent.
No, regarding deduction. Question is with regard to deductions, it should be the dependents.
Yes, sir.
But whether with regard to legal representative, yes,
They are
they
entitled.
may not be
They are entitled.
dependent.
They are entitled.
With regard to legal representatives, all the legal representatives.
Representative, that is the basic conception and that is the law, that is statute. The Punay Shetty and Sorla Bharma, the judgment, Sorla Bharma and Punay Shetty, there is the basic, subject to correction and lawsuit, gone through the both judgment in several occasions. The difference between Sorla Bharma and Punay Shetty, Sorla Bharma, in that case, if is the self-employed person, so no future person. Sorla decline.
No, that's a different issue. Regarding
The Punay Shetty case, Punay said, no, all are will get, but the ratio is there, 40%, 30%, 25%. And lordship the question is the family person. The legal representatives are entitled. The legal representative 4. The Sorla Bharma, all the judgment lordship will have. If the family person is the legal is 4, then 1/4 reduction. Lordship kindly come to the judgment of the Punay Shetty. The submission advanced by the learned mind.
Punay Shetty regarding the dependents.
Not dependency.
All claimants.
All claimants. Lordship, may I humble submission subject to correction, Lordship. Dependency, that word has no application in the motor vehicle.
No, Punay Shetty. What is it?
Even Punay Shetty. With keeping in my
So simpliciter claimants.
Simpliciter claimants. Dependency. Suppose the daughter is a married daughter. She is not entitled. Suppose the son is a married son. Even then he is entitled. So what is the difference between son and daughter? There is no difference. There is no difference at all. If sons in earning more, that judgment has placed. While lawsuit found the sons earning more.
Now let us see regarding deduction, Punay Shetty. What is the language used?
আপনি দিন না judgment আপনার
সরলা ভার্মাকে দেখো না, সরলা ভার্মা প্রথম দিকে লেখাই আছে ডিপেন্ডেন্ট। অন্যদিন ফিক্স করো, অন্যদিন
কেন
করবেন?
kindly come to that therefore multiplier to be used should be mentioned table prepared and social samaj. That is the multiplier. Just
সরল ভার্মাটা দেখো, সরল ভার্মাতে ভালো আছে। The fix is day after tomorrow.
why? This is the only issue.
Let me see.
Earlier occasion you have so taken time. So kindly There's so many. There's some basic. So kindly come to paragraph 12, sub paragraph 12. Adjournment. দিন আমি পেয়ে গেছি, ওটা আপনি খুঁজছেন কি হবে? আমি দেখিয়ে দিই বসে। পেপারটা দাও। বসো, রিল্যাক্স করো। Lasu, kindly basic concept from the Sola Varma. Lasu, kindly see that Sola Varma.
No, I'm just going to that personal deduction. Future prospect is there.
Yes.
Multiplier is also there. Regarding personal deduction.
That is there, Lasu. Lasu, kindly give me 1 second. I'll give you.
এই দিন তো একটু
To kindly see from the Sola Varma. Lasu, this is the paragraph. Just this page, first paragraph.
last paragraph.
Yes, just first paragraph. This page, first paragraph. Lordship, that conception is that if they married, she is not dependent upon his father, that evidence is not there. So if the son is entitled to get the entire, even the married daughter was getting entire, there is the Lordship Virendra that I have placed.
Yes. For this legal representative.
Yes, legal representative. But conception, with that conception that if the married son is entitled, the married daughter also entitled. But you kindly see the paragraph 30 of the ownership. এটা কথা
From the schedule, how much? In schedule, uniformly, 1/3.
1/3.
If that schedule is followed.
Maybe, Lordship, maybe.
Uniformly 1/3. Yes, the language uses dependent family members.
Yes, Lordship. Lordship, kindly come to the Solama case, paragraph 15.
Paragraph 15.
Sorry, Lordship, Virendra. Virendra, paragraph 15.
Which case? Virendra.
Virendra.
Yes, paragraph
15. It is thus settled. Lordship, got it?
Yes.
It is thus settled by now that the legal representative of the deceased have a right to apply for compensation, having yes, having said that, it must be necessarily follow even the major married son of the deceased being legal representative has right to apply for compensation. Lordship, kindly see that is actually my humble submission that I fails to submit before your Lordship. Applicant, irrespective of the fact that whether the concerned legal representative was fully dependent on the deceased, not to limit the claim of limit. Lordship, got it this paragraph?
Yes. Next issue.
Paragraph 15.
Yes.
Kindly see that is my humble submission. For the reason I am asking for 1/4. Earning son of the deceased being legally preceding have a right to apply compensation. It would be bounded duty of the tribunal to consider the application irrespective of the fact whether the concerned legal representative was fully dependent on the deceased and or not to limit the claim towards conventional heads only. The evidence on record, the present case, they would be suggested that the claimants are working in the agriculture labor. He also like that the contact the business were earning much meager income between some, and it insists that's why larger family dependent on earning of their mother. In fact, they were staying with her to meet with the accident age of 48. So, Lordship, that is the observation of the Virendra.
So this is what para 13 Tilak Chandra. Tilak Chandra, that is uniformity if it is to be followed, married person, second schedule 1/3.
Tilak Chandra, Suma Thomas, that case was the 93-94. where the nowadays, Lordship, in the judgment of Saulabama University, the schedule is appending in the WAC that has no Lordship application.
No, Pronoyeti does not say regarding that personal deduction how much. Sarola Verma says.
Saulabama said that.
Yes, now Sarola Verma, you see.
Just last paragraph.
No, Sarola Verma, there is that is last page,
First paragraph.
49.
Lordship.
Here also you see the term dependence is used.
Family, but he is not dependent. That evidence is not there. Lordship, that's why I am saying, asking Lordship, suppose Lordship, the wife is the employed person and husband was the employed person. So on death of husband, the wife will not get the entire
That is there, but you see, married daughters are usually not treated to be dependent. But you see, married daughters are the legal representative. They have a right to claim compensation. But while deducting on the account of personal deduction, married daughters are usually not taken.
The next question is that why Lordship not considered the son in such way? So that discrimination, Supreme Court and the judgment said that discrimination should not be followed because of sons and daughters. If married son, then another conception, married daughter in different conception, that cannot be. That cannot be. All are the sons, meaning no sons and daughters. All are the sons of the sons. That is the Lordship knows that in the Hindu
So
law.
you have the judgment?
That judgment not with me. But Lordship, my humble submission before your Lordship, that evidence is not there. They did not at all put the question before the learned tribunal whether the married daughter was depending or not depending. Beyond the evidence, court cannot go because it is the appeal court. If the original court of law, they fails to put this question. It is not that they are taking advantage before the appeal court by not putting the question before the original court of law. That cannot be. Because the Lordship kindly see means support of my submission, paragraph 15 I am placing that discrimination cannot be followed. Married son and married daughter. Once it is sons, so whatever he is entitled, daughter is entitled. The discrimination cannot be reflected in any order of judicial order. Usually after marriage, the daughter will be residing at her in-laws' house. That is different issue. But there is no evidence. Somehow they are residing there, but entirely depending on his father. It can be. Father can provide the entire maintenance of his daughter. Maybe. But he is also providing to his son. He is providing to his employed wife also. So as you can not to limit the claim towards conventional heads only. As you kindly see the paragraph 15 of the Virender. Virender is after that. And in the judgment of Virender, Lordship, Pronoyeti and Saulabama considered. It is not that not considered. Paragraph 15, Lordship, kindly see. So, Lordship, entire submission, I leave it to Lordship, just I am placing my submission. Paragraph 15. Having said that, it must be necessary follow the event, major married or earning sons of the deceased being representative have right to apply compensation.
You see, maximum it can be 1/5, 1/3 to 1.
Maximum is 1/5.
Maximum 1/5.
Right. That's applicable. And lastly, the second full submission of the 40,000 each has to be given to the parental consortium and the filial consortium.
And regarding the 10%, if it is added, it slightly increases the compensation. If 10% is added, total compensation slightly increases. Yes, you want to add anything?
No.
Yes, take down.
I'm a plasma.
Learned advocates for the parties are present are learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 5th June 2025 passed by learned additional district judge, fast track second court, Purbo Bardhaman in MSC case number 27 of 2018 stroke the 143 of 2018. Stop. The claimants respondents number 1 to 4 being also aggrieved by the judgment and award passed by the learned trial judge has filed a cross objection. Stop. Next para. The case of the claimant's appellants before the learned trial court may be summed up thus. On the fateful date and time, the victim was proceeding with his bicycle along the Shamsundar Road towards Kishan Bazar and Shamsundar Road towards Kishan Bazar, and while he reached near Kishan Bazar, at that time the offending vehicle bearing number WB38Q/7105 coming from the same direction with high speed, rash and negligent manner dashed the victim from behind, resulting the victim fell down on the ground and sustained severe bleeding injuries on all over the body, and he was removed to Barwan Medical College and Hospital for treatment, and ultimately the victim succumbed to the injuries at 12:10 p.m. on the said day. Stop. Rash and negligent driving on the part of the driver of the said vehicle number WB38 capital Q/7105 was the sole cause of the pathetic accident. Stop. The victim was the sole earning member of his family, and he used to maintain the petitioners, and the petitioners were solely dependent upon him, and due to sudden demise, the petitioner stroke claimants have suffered a great loss besides suffering from pain and mental agony. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case by filing Stop. However, the opposite party, National Insurance Company Limited, contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence and upon hearing the learned advocates, was pleased to dispose of the claim application by observing and directing as follows. Eta, page 43, again. The appellant, National Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. The claimants respondents number 1 to 4 being also aggrieved by the quantum of compensation awarded by the learned trial judge have filed a cross objection. Stop. Heard learned advocates. Peruse the petition filed. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that there is delay of 28 days in lodging the FIR, and thus the case of the claimant is doubtful. Stop. Learned advocate further submits that this vehicle is involved in several accidents, and there is every possibility that the vehicle is being implanted. Stop. Learned advocate also submits that the learned trial judge, without considering relevant documents, have taken into consideration monthly income of rupees 6,000 per annum. Stop. Learned advocate for the claimants respondent number 1 to 4 submits that the learned trial judge did not commit any error in coming to the finding of rash and negligent driving by the offending vehicle. Stop. Learned advocate submits that the learned trial judge erred in not taking into consideration personal deduction as 1/4 and proceeded on the basis of personal deduction as 1/3. Stop. Learned advocate also further submits that the learned trial judge erred in not awarding future prospect at the rate of 10% per annum. In view of the decision of the Honorable Supreme Court in the case of National Insurance Company Limited versus Pranay Shetty, reported in AIR 2017 Supreme Court, page 5157. Learned advocate also submits that the compensation awarded should be enhanced. Learned advocate, it is submitted by the learned advocate that the married daughters are also legal representatives, and thus the personal deduction cost in respect of married daughters should also be taken into consideration. Learned advocate relies upon the decision of the Honorable Supreme Court in the case of National Insurance Company Limited versus Birender, reported in AIR 2020 SC 434. The second decision of the Honorable Supreme Court in the case of Sharola Verma versus Delhi's Transport Corporation and another, reported in 2009 3 WBA LR SC 700. Stop. Next. National Insurance Company Limited versus Pranay Shetty, bracket Supra. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that with regard to the first submission of the learned advocate for the appellant, the delay of 28 days in lodging the FIR makes the case of the claimants doubtful. It is decided in different judicial pronouncements that mere delay in lodging the FIR is not fatal. Stop. It is observed in different cases that in Indian society, families of the injured person rushes to hospital and not to police station. Stop. Hence, it cannot be said that delay of 28 days in lodging FIR is fatal. Now, with regard to the submission of the learned advocate that the vehicle involved is implicated in several cases and several claim cases are pending, this court does not find any such pleadings in the written statement before the learned trial court. Stop. No inquiry is conducted in this regard by the insurance company by issuing notice to the driver and the vehicle owner. Stop. The vehicle owner and the driver is also not examined by the insurance company. Thus, the plea that the vehicle is implanted cannot be sustained at this stage. With regard to the monthly income of rupees 6,000, the claimants in their claim petition have stated that the income of the victim was rupees 6,000. Although no documents was filed in this regard, but from the cross-examination of PW1, nothing can be shaken that the victim was a vegetable vendor. Stop. Considering the nature of occupation, it is not quite unusual for a vegetable vendor to earn rupees 6,000 per month. Stop. Thus, this court does not find any error of the learned trial judge to proceed on the basis of monthly income of rupees 6,000. Stop. With regard to the submission of the learned advocate for the claimants respondents number 1 to 4, relying upon the decisions, it appears that in the case of National Insurance Company versus Birendra, the Honorable Supreme Court observed as follows. Set out page 15 and 16. ঠিক আছে? In the case of Sharola Verma versus Delhi Transport Corporation and another, the Honorable Supreme Court observed as follows. Set out page para 49. বুঝতে পেরেছেন তো? In the case of National Insurance Company Limited versus Pranay Shetty, the Honorable Supreme Court observed as follows. Para 39, হ্যাঁ? Para 39 এ শুধু এই দুটো। এটা fold করে দিচ্ছি। Upon considering the judicial decisions relied upon, it appears that the Honorable Supreme Court has decided the issue with regard to legal representative as to who are entitled to maintain a claim petition. Stop. It is well settled that the legal representatives of the victim are entitled to maintain a claim petition before the tribunal. Stop. However, from the decisions relied upon, nowhere it provides that the marriage daughter are the dependents of the victim, as the said decisions are only with regard to the legal representatives and not with regard to the dependents. Maintaining a claim petition by the legal representative is one aspect, and claiming of personal deduction for maintenance of the dependents is another aspect. Stop. Merely the legal representatives are entitled to maintain a claim petition does not give rise to the inference for all the legal representatives the personal deduction will be taken into consideration on the basis of the number. Stop. It is only those representatives who are fully dependent upon the victim should be taken into consideration for the purpose of personal deduction. In case of married daughter, unless a specific case is pleaded with evidence, it would not be reasonable to consider the married daughter as a legal as a dependent while computing compensation and making the personal deduction. Thus, this court does not find any error with regard to taking into consideration 1/3 personal expenses to compute the compensation. However, with regard to the future prospect, this court finds that the learned trial judge ought to have taken into consideration 10% future prospect considering the age of the victim and the occupation. Learned trial judge ought to have you taken the plea regarding consortium?
Yes.
Learned trial judge further ought to have considered the issue of consortium to the mother. Instead of going into the arithmetical calculation, this court is of the view that it would be just and reasonable to award compensation of rupees 6,50,000 to the claimants respondents number 1 to 4. Hence, this appeal FMA 279 of 2026 stands disposed. Judgment and award dated 5th June 2025 passed by learned additional district judge first track second court Purbo Bardhaman in MSC case number 27 of 2018 stroke 143 of 2018 stands modified to the extent that the claimants respondent number 1 to 4 are entitled to compensation of rupees 6,50,000 from the appellant National Insurance Company Limited along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Stop. The appellant National Insurance Company Limited shall deposit rupees 6,50,000 along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the deficit amount, the balance amount be deposited within 8 weeks. The respondents 1 to 4 claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Stop. As the compensation awarded by the learned trial court is enhanced, the claimants respondent number 1 to 4 shall pay the deficit court fees before the
Paid. Yes.
no enhanced amount.
Yes, Lordship, that is enhanced level. Lordship, kindly see.
No, I'm enhancing the amount. On the enhanced amount within 4 weeks from date.
Lordship, the cross objection also disposed of.
The amount that respondent number 4.
No. The claimants respondent number 1 to 4 shall pay the deficits on the enhanced compensation within 4 weeks from date.
Lordship, the cross objection also disposed of.
As both FMA 279 of 2026 and court দেখে নেবেন কত আছে, both stands disposed.
Court Lordship is the court number is 37 of 2037. 37 of 2026.
Court 37 of 2026. হ্যাঁ কি কস্টটা trial courtের কাছে you have to deposit the deficit court fees probably before the trial court. That is the procedure.
That is the procedure. Here is the appeal court cannot.
Because appeal court cannot take the court fees. Only compensation amount.
So I have to only furnish the
order, this order and the deficit court fees.
So that will be deposited before the tribunal.
Yes, trial court. The court fees is always before the tribunal.
That I know. Lordship, only difficulty is that to just apart from that, sometimes we are depositing is online. So Lordship, kindly only direction that deficit court fees paid if not paid. It will suffice. Otherwise, if
how can you pay it? You have already paid it on the compensation amount from the trial court.
Sometimes we are paying online, Lordship. From the
but you submit the document before the register that you have paid the deficit court fees.
That our tribunals kindly directed the two deficit court fees.
No, but who is going to receive that? The trial court.
That receipt we will get. It is a system is there. That system we are using this system. We are using.
Achha, trial court get it in. Pay the deficit court fees. Bas.
Pay the deficit court fees. That receipt.
That proof you submit.
That proof I have submitted.
If both parties are present, I can take it up. Otherwise, I'll take it up at 4 p.m. Yes. If 4 p.m. matters are not present, I'll take up the hearing matters.
The 4 p.m. matter only we need to submit the notes of argument.
Anyway, let him come at 4 p.m. Yes, call the hearing matter.
Milord, this is the appeal of claimants filed by my learned friend Milord.
Milord, I am appearing for the claimant.
Milord, in this case, Milord, with the leave of my lord, sir, আমি বলি এখানে ভুল হবে, প্লিজ কারেক্ট করে দাও।
These applications are all disposed.
Milord, these applications are all disposed rapidly. Milord, it's a very old case, Milord, of claim case of 1997.
2008.
Milord, 2008 is the appeal, Milord.
Oh, appeal. Oh, 97 claim
Claim
case.
case 97, Milord.
163A or 166?
166, Milord. Milord, neither I have the records nor my learned friend have the records, Milord. Now it is, Milord, 30 years, Milord. Now, Milord, the point is the award was passed on a lump sum basis, Milord. It's a death of a bachelor, Milord. 24-year-old bachelor died.
How much was the awarded sum?
Milord, I'm coming to that, Milord. Mother is the sole claimant, Milord. Milord, 1,50,000 was the award, Milord, passed, considering 1997 accident, Milord. Without getting into, Milord, any details of the income of anything, a whole lump sum award was passed. Learned tribunal judge, while passing the award, Milord, considered that there is no loss of dependency. Huh? Paper book nahi, paper book nahi. Milord, we have jointly agreed, Milord, if it
We have agreed,
Milord,
subject to
my learned
lord's
friend, subject to my lord's, Milord, kind blessing, Milord. Milord, award was of 1,50,000 rupees.
With interest.
With interest, Milord. On a whole, Milord, lump sum basis. Learned tribunal judge said that there is no loss of dependency, but there is a death. So 50,000 under 140 and 1 lakh under 166. This is what, Milord, this appeal is all about. Milord, 1,50,000 in total was the award pass. Milord, my learned friend says, Milord, that he did not receive the amount. My client says, Milord, they have paid the amount. Be that as it may, Milord, we will check it up again. If he is not yet, he is entitled to get. There is no confusion about that. Milord, on the last day, Milord, before the other division or the other honorable division bench, when the matter was taken up, Milord, we agreed for a particular sum. Milord, 1997 accident, 2,000 rupees per month calculation. On the basis of that, Milord, 3 lakh.
Second schedule.
Milord, not second schedule, Milord. Milord, because second schedule, Milord, was immediately thereafter. Milord, 1994 was second schedule.
Thereafter, 1997.
It is 99. Milord, Milord, the formula is of second schedule, but the monthly income, Milord, for 1997, Milord, is of 2,000 rupees, what we have considered. Milord, on that basis, Milord, the principal award is of 3,32,400 for this particular accident. Milord, considering 6% interest from 1997, Milord, today it is, Milord, 30 years.
Just a minute. Okay, you sought time to file the paper books.
Milord, he doesn't have the documents, Milord. If we are agreed to this calculation, if my lord can dispose
Calcutta records have also not come.
Milord, they are not required, Milord. We are ready for, Milord, for disposal.
Anyway, let us.
It is 30 years now, Milord. Let them get the money. Milord, this by this calculation, 1997
so if
accident.
Second schedule is followed, he gets this one.
Yes, Milord. Yes. Milord, he will be getting approximately 10 lakhs of rupees, 30 years interest, 180%. 3,32,000 is the principal. So, Milord, 3,32,000 plus 180%, Milord, it is
9,32,000, yes.
So, Milord, they will get the money, Milord. We will also, Milord, be, Milord, relieved of one particular case. He has seen this calculation. We are agreeable to this, Milord. The Lordship will make it in order of the court, dispose it of, Milord. Only on the basis 30-year-old matter, Milord, let it be disposed of.
Let us see.
It will only, Milord, my Lord's blessings is required, Milord.
What was your ground of challenge? That the compensation awarded was meager?
Yes.
And on the lump sum basis?
Yes.
Without following the arithmetical process?
Yes.
And the second schedule?
Yes.
That calculation was prepared.
Yes, where is the order of the under appeal?
Memorandum of appeal, Milord, the award passed by the learned tribunal is attached.
Yes, let me see the memo.
Lordship. That is why, Milord, we sat together, we worked together, Milord, we wanted to finish it off. And the other honorable bench, Milord, was also agreeable to this, but somehow, Milord, the matter could not be taken up, Milord. So,
ঘাট থেকে নামলে বাঁচি
ঘাট থেকে নামলে বাঁচি
এলসিআর আছে ট্রায়াল কোর্টের অর্ডারটা দেখছি আর কি
পাঠিয়ে দিন এই যে
আজ না আমার কালটা করে যাচ্ছি সেদিন বললি আজ রেখে আসবে
Lord, award, my lord, lordship will kindly come to internal page 6 of the award, my lord.
টাকা পড়ে যাচ্ছে তো দিতে পারছি না
Last second paragraph, internal page 6 of the award, last second paragraph, while calculating. Lordship will kindly see.
কেসটি কাটে হ্যাঁ
চেষ্টা করছি শেষ হয়ে যাবে 30 বছর বছর দেখুন আমাকে ইন্স্যুরেন্স কোম্পানি যখন দিচ্ছে হচ্ছে পেড রুপিস 1,50,000 15, 11, 99
না চেক দিয়েছিল চেকটা এটাই করেছিল আমি মিটিং ক্লিয়ার
তাহলে এটা আমাকে বলে তাই জন্য আমি বলছি যদি রিসিভ না করে
হ্যাঁ
ওই চেকটা কোথায় গেছে
ওটাই আমার কাছে নেই তো নিয়ে গেছে
এটা দেখে নেবো হ্যাঁ এলসিআর কোড চেকটা এটা দেখ
আমার ইনস্ট্রাকশন আছে
ঠিক আছে আপনি তাকে পাবেন কি আছে বলে দেখে নেবো চেকটা এলসিআর করে থাকি
Personal expense is 51 half.
Yes, 50%, my lord, bachelor. Yes, my lord, in this matter, we will not be fighting, my lord. My lord, this my lord, it will be disposed of.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was a claimant in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 31st August 2009 passed in MSC case number 371 of 97 and 370 of 97 by learned district judge Bardhaman, presently Purbo Bardhaman. The grievance of the claimant appellant is that the learned trial judge, without considering the principles and guidelines laid down under the Motor Vehicles Act 1988 and without following the second schedule, have awarded compensation of rupees 1,50,000, which in the view of the appellant is meager. Learned advocate submits that the learned trial judge ought to have granted compensation upon following the procedure and guidelines as provided in the second schedule of the Motor Vehicles Act 1988, which was prevailing at the time when the case was taken up for consideration. learned advocate appearing for the respondent insurance company disputes the submission of the learned advocate for the appellant. Stop. Upon perusing the judgment and award passed by the learned trial court, it appears that the learned trial court granted compensation of rupees 50,000 under section 140 of the Motor Vehicles Act and rupees 1 lakh as considering it just and reasonable. Stop. Although courts and tribunals are empowered to pass award of compensation, which in the opinion of the courts and tribunals are just and reasonable, but prior to passing such award, some guidelines and procedures should be followed in the interest of justice. Stop. Thus, in the facts and circumstances of the case, this court is of the view that considering the schedule and considering different judicial decisions, it would be just and reasonable to consider the monthly income of the victim to be rupees 2,000. Stop. Considering future prospect of 40%, which is rupees 800, the net monthly income comes to rupees 2,800. Stop. The annual income comes to rupees 33,600. Stop. The personal expenses at the rate of 50% should be deducted, and the net annual dependency loss comes to rupees 16,800. Stop. Considering the age of the victim, multiplier of 18 should be applied, and the total dependency loss comes to rupees 3,02,400. Stop. Further, the claimant's appellant, there is only one claimant. Claimant appellant is entitled to general damages on account of funeral expenses, loss of estate and loss of consortium to the extent of rupees 30,000. Thus, total compensation comes to rupees 3,32,400 by arithmetical calculation. Stop. However, in the view of this court, compensation of rupees 3,30,000 is just and reasonable. Stop. Thus, this appeal FMA 1010 of 2018 stands disposed. The judgment and award passed by learned District Judge Bardhaman, presently Purbo Bardhaman, in MSC case number 371 and 370 of 1997 is modified to the extent that the appellant claimant is entitled to compensation of rupees 3,30,000 along with interest at the rate of 6% per annum from date of filing of the claim case till today. Stop. The respondent National Insurance Company Limited shall deposit rupees 3,30,000 along with interest at the rate of 6% within 8 weeks from the date of communication of this order before the Registrar General High Court, Calcutta. Stop. In the event the compensation awarded by the learned trial court is already paid, the balance amount be deposited. Stop. The appellant claimant is entitled to withdraw the compensation upon compliance of necessary formalities. The deficit court fees be paid within 4 weeks from date.
I'm grateful to your lordship.
Yes, deficit court fees on the enhanced amount. ওখানে লিখে দিন deficit court fees on the enhanced compensation. On the enhanced compensation, you pay the deficit court fees.
I'm obliged. এখানে লেখা আছে 16/10/99 awarded লেখা Milord 119 is again the appeal of the claimants. It is a case under section 163 capital A. My learned friend is on behalf of the claimant. Milord, learned tribunal judge, milord, for the death of one 35-year-old milord man, has awarded milord rupees 2,65,500. Milord, the sole ground is that, milord, in view of the amendment, milord, and in view of the section 163A, milord, the total compensation ought to be 5 lakhs. Milord, for that deficit of 2,35,500, he has come up before your lordship. Milord, this appeal can also be disposed of, my lord. And enough, milord. Rest this matter as well. This appeal will be disposed of.
Yes, record an order.
Hmm.
Learned advocates for the parties are present. Heard learned advocates. This appeal is directed against judgment and award dated 17/8/2008, passed by learned additional district judge learned district judge Dakshin Dinajpur Balurghat in MSC case number 75 of 2007. Stop. The grievance of the appellant claimant is that the learned trial judge awarded rupees 2,65,500, which according to the claimant appellant is meager. Stop. Learned advocates for the appellant submits that the amount awarded by the learned trial judge should be enhanced. And as per the amended provision, the claimant appellant is entitled to rupees 5 lakh. Stop. Learned advocate for the respondent insurance company disputes the submission made by the learned advocate for the appellant. Stop. Upon considering the fact that this motor vehicles claim legislation is a beneficial legislation, and as per the amendment, all claimants are entitled to rupees 5 lakh, it would be just and reasonable to enhance the compensation amount to rupees 5 lakh. Thus, this appeal FMA 500 of 2010 stands disposed. The judgment and award dated 17/8/2008 passed by learned district judge Dakshin Dinajpur Balurghat in MSC case number 75 of 2007 stands modified to the extent that the appellant claimant will be entitled to compensation of rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The respondent National
The Oriental
Oriental Insurance Company Limited shall deposit the compensation of rupees 5 lakh along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order. Stop. In the event the amount awarded by the learned trial court is already paid, the balance amount be deposited. The claimant appellant will be entitled to withdraw the compensation upon compliance of necessary formalities. Deficit court fees on the enhanced amount of compensation be paid within 4 weeks.
But I'm thankful to my God. This was my important.
Yes.
What?
21, you are 22. Okay, not today. So let it be not today. Let's see on the.
Okay.
127, yes, 128.
Sanjay Pal. Manoj, I have come before your lordship for announcement. This is an injury case, Manoj, case of amputation. Manoj, at first, Manoj, kindly see page one of the paper book. Victim was aged about 41 years. Manoj, kindly see page one.
Yes,
Victim was aged about 41 years.
yes.
By profession, he was police mistri. Self-employed and claim was 5,000 per month. The accident took place in the year, Manoj, 2nd May 2014. My lord, next page, my lord, page 3, my lord, paragraph 23, my lord, how accident has been happened, that has been narrated. My lord, there is no dispute regarding rash and negligent driving. My lord, here, my lord, on 2nd May 2014.
Page?
Page, my lord, 3. Page 3, my lord, bottom portion, your lordship will find when
Yes.
accident has been taken place. Accident took place on 2nd May 2014. Or in the year 2014, my lord, national income used to assessed by this honorable court in several decisions. My lord, your lordship will find that 4,000. 4,000. But learned judge has taken national income, my lord, 3,000. First point is this, my point is this. And my lord, kindly see page 9. Well, that is the deposition of the claimant. Paragraph 9.
Page 9.
Page 9. Deposition of the claimant. Paragraph 9. Your lordship will find from this paragraph that the right leg of the victim has been amputated, and my lord, a sum of rupees 3 lakh has been incurred towards treatment. And thereafter, paragraph 6, your lordship will find, my lord, the Balurghat district hospital, my lord, declared 80% disability, permanent disability, due to, my lord, amputation of the leg. That has been, my lord, exhibited. Document has been exhibited. Document.
So it was by the board?
Board. That has been board. My lord, kindly see the PW3. My lord, kindly see PW3 page 16.
Yes.
I am physiotherapist now posted at Balurghat district hospital. He, my lord, proved the disability certificate. Page 16, my lord.
Page 16, yes.
Exhibit 14, my lord.
Yes. So this was exhibited without objection?
That has been exhibited without objection. My lord, next page your lordship will find. With objection.
No, with objection.
Yes, here it is related with objection. My lord, it is a case of amputation. That has not been disputed.
No, but 80% disability.
80% disability.
And tribunal will not consider.
Consider 80% consider. That has been considered. That is not matter dispute. Dispute is matter regarding income, future prospect. Income, future prospect. And my lord, kindly see, my lord, I am coming main course. My lord, kindly see page 29. Page 29. It is found, my lord, second paragraph. It is found. My lord, the first paragraph, exhibit disability certificate, exhibit 14, that has been accepted by the tribunal below. That your lordships will find from the same page. It is found that at the time of alleged accident, the claimant was earning a sum of rupees 300 per month, that is rupees 36,000 per annum. Now, as the claimant was self-employed and aged about 41 years as such, in accordance with the decisions of in the case of National Insurance Company Punai Safety, 40% has been added towards future prospect, and thereafter, my lord, kindly see how calculation has been made, and 3,000 rupees has been taken.
More than.
কোথায়? না এখানে ক্যালকুলেশনটা দেখো হ্যাঁ হ্যাঁ
But for that, the lordship will find that the claimant are entitled to get 25% future prospect. The land tribunal granted 40% future prospect. That should be reviewed.
মানে here
Income must be very well. 3,000 land tribunal granted 3,000 notional basis. It can be 4,000. That is all right. But here, my lord, the 40% granted should be 25%.
My lord, thereafter I am coming, my lord. Kindly see thereafter the heads. Expenses.
So tribunal, so there is no cross appeal.
Not cross appeal, but only the first appeal.
But ultimately the grant is excess there. Not excess here, although that 1,000 is not taken, but there he got some.
Other, my lord, here, my lord, kindly see expenses treatment, my lord, given, my lord, 1,19,670, loss of income, 5,64,000, my lord, that calculation has been made here. And thereafter, mental pain and agony, my lord, 50,000 only has been given. It is a case of amputation. The carpenter lost his, my lord, working capacity.
Period of stay in hospital?
Pure stay in hospital, my lord.
How many days did you stay in hospital?
Yes, 3 times, my lord, he admitted. I am coming, my lord, here. Your lordship will find, my lord. My lord, kindly see once again, but paragraph 9 of page 5, page 9. I was admitted at Anandolok Hospital and Neuroscience Center at Siliguri from 3/5/2014 to 17/5/2014. After discharge from Anandolok Hospital Neuroscience Siliguri, I was admitted at North Bengal Medical College and Hospital Siliguri from 7/5/2014 to 22/5/2014, where my right leg was amputated above knee, and I had already expended rupees 3 lakhs. 2 times my leg has been amputated before the government hospital. That document has been exhibited, my lord.
So regarding expense of treatment, you have nothing to say.
My lord, only 1,90,000 given, my lord, that has been proved by
Loss of income also is there. Pain and agony 50,000.
Only 50,000 in a case of amputation.
And expenses of medicine 10,000.
Only, my lord, expense of medicine and special diet 10,000, conveyance 10,000, damage of motorcycle 30,000 has been given. And my lord, your lordships will find this is a case of
damage of motorcycle can't be. Because own damage. That is own damage claim.
Only personal damages.
Only personal injury case. Only personal health damage.
No.
Damage of motorcycle.
Not property.
No, that is there, my lord. In the schedule, that is there.
Damage of motorcycle.
That damage of property. Damage of property is there.
Damage of property and a tribunal. That is the defined forum.
Yes, in the accident claim, this award has been granted.
And here your lordships will find that no interest has been given 5% only. And your lordships will find this is a case of amputation. In a case of amputation, the Honorable Apex will say, our High Court also, in several times, my lord, expenses for prosthetic limb artificial leg.
There is no evidence.
My lord,
There is no evidence as adduced. Only on the basis of submission. My
no,
lord.
no,
Only there is
my,
no evidence.
no, my lord, kindly
Where is
see.
the evidence?
Evidence is there. My leg has been amputated.
Yes,
For medical expenses, you have proved that that you have purchased any artificial leg.
No, my lord, that has not been proved. But my lord, in the head, my lord, several times, my lord, honorable Appellate Court, my lord, awarded. In Sayyid Saddiq.
There must be evidence. Evidence on
artificial limb, my lord.
There is a my lord, organization.
My lord, kindly see. In a
artificial
case of
limb,
a
that
in a
quotation is
in
required
a
to.
in a case of a my lord.
No, are you using artificial limb?
No, my lord, I am not using. My
Then where is the purchase?
my lord, I shall purchase after getting, my lord. My lord, kindly see page 89. Page 89. My page, my lord, 379 of the judgment. 379, paragraph, my lord, 26. In a case of amputation, how much has been granted? In 2014, my lord, this judgment has been awarded in 2014 by the Apex Court. And my accident has been happened in 2014. Towards my lord, pain and suffering, 60,000. Towards medical and incidental expenses such and such. Towards loss of amenities, my lord, 50,000. This head has not been.
No, what
considered.
was the facts before
Facts,
that?
facts, my lord, amputation. He was a vegetable vendor, my lord.
No, this case.
In
Before
this
the
case.
Honorable Apex Court, what was the facts?
This is a case of amputation, my lord. This is victim was a vegetable vendor.
Oh, this is medical expenses.
Yes, 6,000, my lord. 6,500 has been taken.
No, where is this?
But my claim is, my lord, 5,000. My claim is 5,000. My lord, kindly see, my lord, 374, paragraph 9.
374.
Page 374, paragraph 9.
Yes.
There is no reasons in the instant case for the tribunal and High Court to ask for evidence monthly income of the appellant claimant. On the other hand, going by the present state of economy and the rising price of agricultural product, we are of the inclined to believe that a vegetable vendor is reasonably capable of earning rupees 6,500 per month. My claim is 5,000. My claim is not more than that. In the case, my lord, your lordships will find in the case in hand, my lord, accident has been happened in the year 2014.
So the Learned Trial Court proceeded on the monthly income of rupees 3,000.
3,000.
And as per the future prospect,
40% granted.
40% it should be 25%.
And my lord, the other heads.
Regarding prosthetic leg, in fact, my lord, they have not paid for us. In the claim application, no prosthetic leg.
This is not non-pecuniary head. It is non-pecuniary head.
In the evidence also.
In the non-pecuniary, that has to be granted, my lord.
You are paying prosthetic leg. Whether your prosthetic leg is required or not, where is the evidence?
My lord, I am amputation, case of amputation. This is the case of amputation.
That is, yes, prosthetic leg is.
So question is, medical expense you have furnished bill.
Yes, that has been, my lord, proved by PW4.
And regarding prosthetic, what is the quotation? What is the money is required for prosthetic leg? There is no evidence. There is no prayer for prosthetic leg. Now
the Honorable Apex Court also considered that also. After considering all aspects, my lord, there is no evidence also. Even then, my lord, principal.
Not required. In claim case, no evidence, no pleading, nothing is required. Only on the basis of Honorable Apex Court judgment, the compensation can be done.
My lord, the evidence is already there. My leg has been amputated.
Have you paid for prosthetic leg any?
That will be that.
Have you paid for?
To
any evidence?
assess just compensation, the court will decide. To assess just compensation, court will decide.
Amputation, no dispute. Learned Tribunal considered 80% amputation considered.
No, in his examination in chief, anything that leg is used.
Consider examination chief. Whether they have paid for. You can come to page 5. Sorry, page 8. Page 8. Nothing. Thing is being paid for. No prosthetic leg.
দাঁড়াও Madam, kindly see page 8, paragraph 8. After the accident, I cannot walk without help of catch, and I cannot work as police mystery before. I am now jobless.
No, that
and
is
permanent
considered.
disable.
Jobless, that is considered.
Yes, I am.
The artificial leg is future medical expenses.
Yes, artificial days is coming for
Without help of crutch.
Yes. Well,
Crutch is not very costly. Crutch is not very costly.
That is very costly, but Bala, it is required for my.
So how much you will get for crutch? Suppose if crutch.
My lord, my lord, regarding artificial leg, 50,000 has been awarded in 2000.
No, where 50,000? Crutch, artificial leg and crutch
Nothing,
is
But
not same.
artificial leg is required. Due to
5,000 to
amenities.
10,000.
My lord, due to amenities. Then my lord, amenities. On the head of amenities, nothing has been granted. On the head of amenities.
Only one sufficient, my lord. Whatever that granted landmark tribunal, kindly do not disturb. Only grant some award, maybe 1 lakh or my lord.
Why?
The heading general.
5,000, my lord. My claim was 5,000.
Very well, my lord. Claim 5,000. Charge for 4,000.
So for future prospect is concerned, he got 25% instead of 25%. He is awarded 40%.
That should be. That is why. That is why on the basis
My lord,
of that
He is compensated already.
already compensated.
My lord, in
That
a
is why-
case,
that is
in
why
a
I say
case,
that kindly do not touch the award. Kindly
In a-
grant some compensation on the
on the
head of
non-pecuniary
general-
head, my lord, kindly see in a case of a, my lord, amputation. In a case of a amputation, my lord, kindly see under the non-pecuniary head.
You see, things can be stretched to a far many distance.
That is why-
But-
that is- may I consider
You
that?
can
That is
submit
why-
many things. It can be stretched to infinite things also.
It can be. I can submit. That means they can. That is why I say kindly do not touch
This
the
is not a,
award.
this is,
Only grant, my lord, some.
a person
general
has
damages.
become jobless.
I submit to your
A
lordship, my
police-
lord, kindly grant some general damages, my lord, and dispose it.
My lord, your
Here, I think there's no question of general damages. This consortium and all these things does not come.
Only under the heading of pain and suffering.
Medical expenses was proved.
yeah,
That
that
is
has been
given. That is
So
given.
your
My lord,
grievance
kindly-
is
kindly
no.
see
Your grievance is future prospect and this notional income.
interest, notional income, my lord, notional income, future person and non-pecuniary head.
How can you be aggrieved of future prospect when you are getting 40%?
Income, interest, and under non-pecuniary head. The amount which has been assessed in a case of amputation under non-pecuniary, that is much.
That is
lesser.
notional income, not 4,000, 3,000 proceeded with, and non-pecuniary damages on account of this pain and suffering and expenses of treatment.
Expenses of pain and suffering, expenses of my lord, amenities in life.
4,000.
Amenities in life.
Future prospect will be reduced. Then amount will be the same. Amount would be that. That
The
is why
amount-
I am submitting. They must kindly do not.
That means he is already compensated.
Already compensated. That is why I must kindly grant for some.
Only what your artificial limb costs.
Yes. No, my lord, kindly see loss of amenities in life. The head. Loss of future, my lord, medical expenses.
Okay, take down. Learned advocates for the parties are present. Are learned advocates. The appellant before this court was an
And interest also, my lord, only
Limit.
5%.
before the in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 14 July 2022 passed by learned additional district judge third court at Balurghat, Dakshin Dinajpur in MSC case number 24 of 2015. Stop. The case of the claimant appellant, next para, before the learned trial court may be summed up thus. Para, that on 2/5/2014 at about 17:00 to 17:15 hours, the injured was coming from Kumarganj side via 10 Mile to Balurghat Hospital for consulting with a doctor at Balurghat, and one Bipul Sarkar, who was the pillion rider of the motorcycle bearing number WB3062B stroke 7122, injured pillion rider, ঠিক আছে? The motorcycle was proceeding, আচ্ছা ওটা লিখে দিন, injured petitioner was the motorcycle driver. Stop. The motorcycle was proceeding at a normal speed on the left side of the road. Stop. When they reached at 10 Mile, at that time another vehicle bearing number WB62 capital A stroke 8247 Tata Indica car was coming from Balurghat side towards Gangarampur side at a very high speed and negligent manner. Stop. Due to rash and negligent driving by the driver of the offending vehicle, which lost his control over the vehicle and came into wrong side, dashed against the motorcycle of the injured petitioner at the extreme left side of the road and fled away from the place of occurrence. Stop. Due to that accident, the petitioner and pillion rider Bipul Sarkar fell down on the road with their motorcycle and got multiple severe injuries on their persons, and the pillion rider Bipul Sarkar died on the spot for his accidental injuries. Stop. The petitioner being injured was admitted to Balurghat District Hospital, but considering his injuries, he was referred to another medical college and hospital and admitted at Anandolok Hospital at Siliguri. Stop. Thereafter, he was admitted at North Bengal Medical College and Hospital, where his right leg was amputated above knee. Stop. Due to rash and negligent driving by the driver of the vehicle bearing number WB62 capital A stroke 8247 was the sole responsible for the accident. Stop. The victim was a man of active habits and good health, and he earned regularly from his occupation and contributed the entire earnings for the expenses of his family. Due to the accidental injury, the petitioner has sustained great financial loss and mental pain and agony, and will have to suffer throughout his life. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party vehicle owner did not contest this case. Stop. Opposite party New India Assurance Company Limited contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial court, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 30, folded page. The appellant claimant, being aggrieved by the quantum of compensation awarded, has come up with the instant appeal. Stop. heard learned advocate for the appellant and learned advocate for the respondent number 1 insurance company. Peruse the evidence adduced. Yes.
My lord, medical expenses has been, my lord, 1,94,400.
Yes.
1,94,400. My lord, kindly see. My lord, I need. My lord, page 19, your lordships will find.
No. How much is awarded?
1,19,000.
But it was 1,94,000.
Yes, my lord. Kindly see, my lord, for a moment.
It was proved 1,94,000.
Yes, my lord. Page, paragraph.
But 1,19,000 awarded.
1,90,000 awarded. My lord, kindly see, my lord. Here your lordships will find from paragraph, my lord, page 18, bottom portion.
Yes. No, it is there. That is you have exhibited. Okay.
Yes.
1,270,000. Okay, 94,000.
And 1,270,000.
That means 1,94,000.
Yes.
এটা হয়ে গেল কি বললাম হার্ড লার্নেড অ্যাডভোকেট and respondent number 1 UNT National Company peruse the evidence adduced and the materials on record. Learned advocate for the appellant submits that the compensation awarded by the learned trial court is meager. Stop. Learned advocate further submits that the learned trial court ought to have considered the notional income of the injured person to be rupees 4,000 instead of rupees 3,000. Learned advocate also submits that the learned trial judge, instead of granting compensation of rupees 1,94,000 on account of medical expenses, have granted compensation of rupees 1,19,000. It is submitted that the compensation on account of pain and sufferings is also meager. Learned advocate for the respondent number 1 insurance company submits that the learned trial judge has granted reasonable compensation which should not be interfered with. Stop. Learned advocate further submits that although rupees 4,000 is not considered as the notional monthly income, but the learned trial judge has awarded 40% on account of future prospect instead of 25%. Learned advocate also submits that the account or that the compensation on account of non-pecuniary heads is not unreasonable. Stop. Upon considering the facts of the case and upon hearing the learned advocates, this court does not find any error on the part of the learned trial judge in computing the compensation with regard to loss of income. Stop. Although the notional income of rupees 4,000 is not taken into consideration, but as 40% is awarded on account of future prospect, any interference on account of loss of income should not be made. Stop. However, the compensation on non-pecuniary heads, namely on account of expenses of medical treatment, both present and future, and pain and sufferings, this court is of the view that the compensation already awarded should be enhanced to rupees 9 lakh, which in the opinion of this court is just and reasonable. Thus, this appeal FMA 21 of 2023 stands disposed. The judgment and award passed by learned Additional District Judge, 3rd Court at Balurghat, Dakshin Dinajpur, in MSC case number 24 of 2015 stands modified to the extent that the claimant appellant will be entitled to compensation of rupees 9 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Stop. The respondent number 1, New India Assurance Company Limited, shall deposit before the Registrar General High Court, Calcutta, rupees 9 lakh along with interest of along with interest at the rate of 6% per annum. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event the amount awarded by the learned trial court is already paid or deposited, the balance amount be deposited. The claimant appellant will be entitled to withdraw the compensation amount upon compliance of necessary formalities. The claimant appellant shall pay the deficit court fees on the enhanced compensation within 4 weeks from date. Yes, you have concluded on the earlier occasion.
We have concluded.
You have concluded.
Yes, yes.
Only
So-
my submission is remaining.
Submission means your written notes only.
Written
Yes.
notes.
Written also দিয়ে দে।
Have you come with your written notes?
I have already filed. It
You have
is
already filed.
filed.
Very well. Let him. Written notes along with relevant.
All the judgments that I have relied on.
আমাকে একটা দে।
হ্যাঁ তোমায় কপি দিই। এই রাহুল কপি একটা আছে তো? দেবাঞ্জন স্যারের কপি একটা দিয়ে দেবে। দিচ্ছি তোমাকে 5 মিনিট দাও। My lord, I have pointed out as the grounds which have been taken by Mr. Mukherjee. I have countered those grounds. I have relied on a few judgments. I have annexed those judgments as well. I have mentioned the relevant paragraphs also. And my lord, the only point is that they have taken is that first there was after the accident, there was an FIR. It culminated into an FRT within a very short span of time. After that FRT, there was a Naraji petition was filed and there was an order of reinvestigation by the Honorable Court. After the order of reinvestigation, the IO conducted the investigation and filed a charge sheet. On the basis of that charge sheet, the court has relied on that, and the evidence which has come up on record, it has been relied on, and then the court proceeded to give an award. We have not challenged the award, the quantum of the award.
There is no counter of
No cross objection in all the 3 matters. Neither of the 3 matters we have filed any cross objection. It's only their grounds of appeal which we have countered. We have relied on the relevant judgments. Only one thing, my lord. My lord will kindly just for your lordship's convenience, come to page 7 once of the notes of argument. Page 7.
Page 7, yes.
My lord will kindly see, this is the vehicle which was moving from Behala towards Taratola. My lord will kindly see the point of impact. Now there are 4 seats. The claimants before your lordship, I have made one at page 4 of the notes of argument. My lord will kindly come to page 4 once. I have mentioned, my lord, what are the details of the accident, the timing of the accident, the date of FRT, the date of filing of the charge sheet, the offending vehicle, the victimized vehicle. Now, my lord, at the last bottom portion, my lord will kindly see passengers of the victimized vehicle who are before your lordship. Kashinath Adok, who was the driver, he is dead.
Driver come owner.
Driver come owner. He is dead. Second, my lord, Shontu Pole, sitting at the front passenger seat. he is also before your lordship in FMA number 672 of 2021. This is an injury case. There are three matters together in this matter. The first matter, FMA 192 of 2021, it is a death case. Second matter, it is also a death case, and the third matter is an injury case.
So three cases are
together because the facts are
three
same.
appeals, my lord, which we have filed in.
One was an injury case.
Yes.
One is the injury case and two death case, and that is the reason.
Three different cases were filed.
Yes.
Yes.
And we have
Giving rise
filed,
to three different appeals.
yes, and we have filed three different appeals in respect of challenging the same order.
No, not the same order. Three different orders.
Three different
Three
orders,
different,
but the
they-
same accident.
Same
Same
accident.
FIR,
three
same
different
FRT,
cases.
same charge sheet, everything. So, my lord, kindly note that there are 4 occupants of that vehicle. The driver was sitting in the front, he died. The one sitting on the left hand side front, he, my lord, is the injured person who is before your lordship, Shontu Pole. Now, my lord, Shopon Pramanik was sitting just in the passenger seat behind the driver, Kashinath Adok. So the impact, my lord, of this accident was on the right hand side front, as a result of which both the passengers on the right hand side of the car has died, and both the passengers on the left hand side of the car has survived. Now, one of the persons sitting on the left hand passenger side is the FIR maker, and the person sitting in front is alive, is an eyewitness to the accident.
So it was against unknown vehicle.
It was initially against an unknown vehicle. Thereafter, FRT was given because, my lord, it was not an unknown vehicle per se. The FRT was given because the police authorities did not find the CCTV footage or any evidence. Initially, the vehicle could not be traced. Now, subsequently, the vehicle could be traced. The offending vehicle number was provided, and police, there was a reinvestigation order, and then the charge sheet was filed. Now, my lord, what is interesting is another point I would like to clarify. Mr. Mukherjee had taken that point that one of the persons was related with one of the victims who took the body of the victim.
No, I have not said related. I have said the person who is the eyewitness has said that
he took
has
the
taken
body.
the body. Huh?
I have taken the body. Now, my lord, the eyewitness who has taken the body, he is saying that this is the eyewitness and he has gone and taken the body. How do we know that? What is the document on the basis of which we are making this submission? Because if my lord kindly have a look at any of the cross-examination of the eyewitnesses, no question, not a single question was put to the eyewitness that why did you go and bring the body? Why did you go and receive the body from the hospital? We just know that a person named Jishu Mondol went to the hospital to receive the body. Whether that person is this person or not has not been proved, because they have not put this question when he came to adduce witness. Not only that, my lord, the conduct of the insurance company is an absolute farce. Why? I'll tell you, my lord. When one of the victims who was in the car and who is an eyewitness to the accident, he went before the tribunal and he stood in cross-examination. Not a single question was put to him that whether this person, whether he is related, whether you know him, why did he receive the body? Not a single question was put. And one thing Mr. Mukherjee has conveniently suppressed is that both the eyewitnesses that we have.
Eyewitness was sitting inside the vehicle.
Yes.
There is only one eyewitness.
One eyewitness. There are two eyewitnesses. Another eyewitness was standing near the pawn shop at 1:15. Mr. Mukherjee.
Did he depose in this claim case?
Yes. He came and deposed in this claim case. Mr. Mukherjee took up one point that why was he standing at 1:15 at a pawn shop in the middle of the night? Well, it was during the Durga Pujas. The accident happened during the Durga Pujas. It is quite normal that at 1:15 during Durga Pujas, the whole night the shops remain open. It is quite natural, my lord. But more interestingly, there was an investigator appointed by the insurance company. the insurance company chose not to produce that investigator as a witness. There was the IO who gave a FRT. That IO was not called into witness. The charge sheet, the person who submitted the charge sheet, that's a different IO. He was not summoned. The victim who appeared before the tribunal and faced cross-examination, he was not put into question.
How many witnesses were examined by the insurance company?
None, not a single witness. And my lord, most interestingly, the fact that this case initial FIR culminated into FRT was known to the insurance company from day one, because they have taken this point that this has there is a FRT. They chose not to produce the FRT. We went and put the charge sheet because it was our case that this vehicle is involved and charge sheet should be filed. That's why we put the charge sheet in. Now, my lord, I will not go further into the facts of the case. I have concluded all the points. I have countered all the points, and I have relied on several judgments. My lord, I have produced all the judgments and annexed. I have given a copy. If Mr. Mukherjee wants to counter any of those points, Mr. Mukherjee can.
I have already stated this in my written notes and argument. And what is there in the learned court below's record, I cannot improve. It is a fact that we have not given any witnesses. I cannot improve that. I cannot stand here and say something which is wrong. And I have in detail, I have given the written notes and argument. I have pointed out the page numbers and everything.
That's all?
That's all, man.
Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. The written notes of arguments is filed by the learned advocate for the appellant be kept with the record. Learned advocate for the respondent. Number 1.
My lord, all the respondents, my lord.
Number 1, 2.
My lord,
respondents in the appeal.
Respondent claimants, my lord.
Respondents claimants be kept with the record. Hearing is concluded. Let this matter appear for judgment on Because 13/7/2026. Huh? Only 15/7/2026.
Deeply obliged, my lord.
I'm good.
My lord, one thing, my lord. In the morning, my lord, I mentioned that item number 182, which, my lord, 2 occasions, my lord, your lordship desired to place the matter as to be mentioned. Now, my lord, it is fallen from your court officer that today it will be called on. Item number 82, my lord,
Item 82 or 182?
182.
এই 182 টাকে টু বি মেনশনড ওটা কবে পরশুদিন তো
কালকে
আচ্ছা ঠিক আছে কালকে টু বি মেনশনড দিয়ে দেবেন 182 টা হ্যাঁ হ্যাঁ এটা ঢুকিয়ে দেবে